Yeah, yeah. Party people, let me see you now. Throw your hands up, yeah. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me, yeah. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me, yeah. We got the, yeah, yeah. Party people, let me see you now. Throw your hands up. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes.
Hello, everyone, and welcome to today's stream. Welcome back to That's My Opinion. My name is Bacon Bears, and it is June 3rd of 2026. Hello, everyone. E-Broccoli Pork Chop is doing great. Good morning, everyone in the chat. Good morning, replay crew. We are going to get right into it. We're going to be watching the hearing today, and it's about an hour, so I want to make sure that we start as quickly as possible because we know that I like to stop these things and I like to talk. So with that being said, I hope everybody is doing well. If you are not subscribed already, please consider doing so. We go live usually every day, but obviously we're on a summer schedule, although I'll be going live 4 days a week starting next week. We have a members only Discord. We have membership perks. We have all sorts of fun stuff. Thank you, Massborn, for the jewels. I appreciate that. Yeah, and that's all I know for right now. So today we're going to be covering Laura Owens versus Greg Gillespie. This was the hearing that happened on August 17th. And this was, why are we doing this? Let me see. I have it pulled up here, or I did. Let me go to our trusty source of Volo. Let's see. My hair is super. Thank you. I appreciate that. Okay, listen. I saw a girl who was doing like a crimper, and I always I have a big crimper and I hate it. And then she's like, I saw this girl who was like, "Do you hate your crimps?" And I'm like, yeah, it was on TikTok, of course, at like 11:30 last night. So she's like, if you take the crimper, everybody wants to do it horizontally to their head. She's like, take it and do it angled downward and backward, and it makes your waves look so much more natural. And I was like, I love it. I love it. I love it. I love. Chronically been on replay crew, but made it here for live. Thank you. Trash Panda Mom. Any relation to Trash Panda that's always in our chat? We welcome you. We welcome you. So today, let's see, Greg Gillespie, I just want to read the little overview that we have of why we are here, why we have all gathered here today. Where am I? Oh, another hearing for Greg Gillespie's motion to dismiss the abortion coercion case takes place. But this is the first hearing that we see. So that's all I know. That's all we have. And I saw the same damn. Is it the one of the girl talking to herself? She's always like talking to herself and she does her hair. And then the one, be right back eating a crimper. I knew it, Moose. She's always talking to herself and she's like, oh my God, how do you do that? I hate whatever. And then she does it. Anyways, gotta bleach your hair first. All the cool guys are doing it. Jacob! Hi! You know what? I know you say Yaku, but now because you told me that story, I'm never going to be able to call you anything other than Jacob. Okay. So, with that being said, this is, yes, I love that girl. I love her when she explains like how to do, and it's so funny because I'm a hairstylist, but there's certain styles that like don't, I don't know, whatever. I get to do what all the kids are doing. Madagascar, All hail King Julian. I need a King Julian for my soundboard. So this is the first hearing that we actually see. And of course, we get all of our sources from Schnitzel Ninja. So that's what we're doing today. Let me see. Will this work here? I don't think so. So I'm going to make myself a bit smaller. I have, sometimes I have the live chats on the screen. And with that, let's get started.
In CD 2021.
Oh, wait, no. I cannot be blocking Zaddy. Hold on. We're going to have to, where am I here? No, I can't go away, but we can't be blocking Zaddy? What? All right, I'll put me up here because we can't block the Zaddy master. He's up here, or he's right here. So who do we have? We have Allison Backus, who is the judge. We have Kyle O'Dwyer, who would eventually withdraw because Laura Owens has had 137,000 lawyers. We have Zaddy Woodnick, which we love. We stan. Where's our anthem? What anthem? The Zaddy anthem? I love her also, too. I went to cosmetology school. Greg class. Hey, I'm glad you're not just talking about, you're just talking about hair, not head cheese. Head cheese took us off the rails the other day. I don't know. Yako was my buddy's name in high school. Oh, so funny. What anthem? Anthem first. Oh, yeah, the Zaddy anthem. Thank you for the jewels, Timmy. And this is Marcus. Who is Marcus? Did you check out Volo for lawyer list? No, but let's see. Hold on. Before we get into this, hold on. Let's see. Oh, the go to trial anthem? Okay. Before we get started, you guys want it at the top of the stream? The people get what they want. That's the anthem is let's go to trial. Go to trial, Laura Owens. It says she's a male. We identify what she wants. We'll listen to your story. Go to trial in Maricopa. We believe you. Tell your story. Let's hear it, girl. We can get it. We believe you. Stay in the mesita. We got you, got you. Do it, do it. Go to trial. We believe in you, Laura Owens. Okay. Morning, Bacon Bear. Hi. Hey, Rob. Hello. Sing it. Let's go to trial. Let's sing it.
Let's go to trial. Sing it, Bacon.
I love his accent. Sing it, Bacon. We believe you. You can't tell me Laura doesn't do hip hop to the casita in this song. She's just like, ooh, I hate it, but it's so catchy. All right, before we get started, the people want us to look at the lawyers. So her first lawyer, Allison Cordova, 2017. Second, Donald McGilligan, 2017. Mr. Cook, 2018. Jason Venditti, 2021. Zachary Mushkatel, 2022. Carrie Ramos, 2022. Kyle O'Dwyer. Kyle O'Dwyer would be lawyer number 7. And then Davis Bauer, and then Bonnie Platter. So we will get there. But Kyle O'Dwyer is attorney number 7. Also, I brought my notepad just in case. I need to write thoughts down so I'm not interrupting the stream every 5 seconds because I'm trying my best not to be annoying. It's important to have a glossy lip for your mugshot. I have to say cheese. I don't know what I would ever have I read Massborn. A mugshot for, but I would hope that if I did have a mugshot, Thank you, Massborn. Welcome to Curious Minds. If I did have a mugshot, it would be for something intentional. I'd smile in that bitch. Cheese. Oh my God. Somebody hit the join button and play so we can hear I'm a sacrifice. There you go. I'm a sacrifice. Adorable hair. Thank you. Also, if you guys have not liked this stream, if you could go out and hit that little thumbs up, it spreads us everywhere like the herps, perps with the herps. And that's what we want to do. We want to make sure that we infect everyone. Okay, here we go. Also, if you guys want to see what I watch a lot of Laura Owens content with you guys, and I've been watching the Alex Murdaugh trial, and I'm on day 5 with Emily D. Baker. If you guys want to watch it with me, that's what I'm doing, and just kind of refreshing because I know we're going to be going to trial again. I watch Swoop, She is a Queen, We Stan, Law and Crime, and more Laura Owens. Like, this is my algorithm. Anyways, okay, let's get started. Hi, Tori.
3 Owens versus Gillespie. This is the time set for oral argument on the motion to dismiss that was filed, motion for judgment on the pleadings on February the 15th after our continuance from last week. Can I have your appearances, please, for plaintiff?
Yes, Kyle O'Dwyer on behalf of plaintiff Laura Owens, who it appears is also in attendance for today.
Thank you.
Why?
Welcome.
Yeah. Why is she not in attendance? Yeah, I love Swoop. Swoop is the best. Why is she not in attendance? Shouldn't she be there?
And for defense?
Good afternoon, Your Honor. Marcus Reisinger on behalf of defendant Greg Gillespie. Greg Woodnick is also
Can the audio be boosted? This is a great question.
in attendance, as is Mr. Gillespie.
All right, let me see. Oh God, I'm going to ruin something. I can feel it in my bones. Okay. So if I don't think I can boost that up anymore, but let's see if I can change the output routing so that this is in the main mix. Hold on. I hope this doesn't cause any, let's see. Okay.
Gillespie himself.
All right, thank you. Welcome.
Okay, hold on. We're getting there. It says I can't bring it up anymore. ¿Por qué no? Because it's a... You know what I'm going to do? I have a call me feature on here. I'm going to have people call me. We're going to have interviews where people could call in. Not right now. I got to figure it out because I'll do something that'll end the stream. It won't let me up the gain any more than it already is. Oh, wait. Maybe if I... Hold on a second. Hold on. Maybe if I put this back... Hold on. I have an idea. Might shut the whole thing down. I might just break YouTube entirely. But if I go in here and I go to filters, audio filters, and then I do gain, okay, and then I gain it up. Let's see. Let's gain it all the way up, bitches.
All right, counsel, any preliminary issues we need to take up before we get started? The court.
Why am I so smart? Okay, that's what I thought. Thanks.
Has read the briefs of the parties, of course. We have the time divided equally between you. I will say that you don't need to use the full half hour that you've been provided. That's a question that the court often gets. Don't feel like you have to fill up a half hour if you don't need a half hour. But I found that half hour total for both sides tends to be a little short, and I don't want to stress people out. So I try and build in a little bit of a question there.
I am the chosen one.
Any preliminary issues we need to talk about from either
No, I want to take stuff from everybody. I got to see. Let me go online and see how I can take calls from my Roadcaster, and we're going to start talking to people. I think that would be such a fun feature at like the end of streams if we could start taking in calls. I think that would be so fun. Do I have to get a separate phone? Let me figure it out. Let me watch some YouTube videos. Okay? Okay.
side for plaintiff?
No, thank you, Your Honor.
No? All right. How about for defendant?
No, Your Honor.
Okay.
Again, why is she not here? It's Zoom. What is she scared? He's gonna get her through the screen.
All right, well, with that, we'll just get right into it. It is defendant's motion, which means that he'll go first. So his attorney will argue first, and then we'll hear from plaintiff's counsel. And then if defense counsel has saved any time, and I'll be keeping time as well. So if you need a time check, just let me know. But if defense counsel elects to reserve some time, then he'll get the last word on the motion by way of rebuttal argument, because it is his motion. So that's how we'll proceed this afternoon. All right, so we'll look forward to hearing what you have to say. On behalf of defendant, go ahead.
Oh, interesting. I wonder, yeah, I'll figure it out. I'll write that down to figure it out. Thank you. I'm glad you guys are saying this about my hair. I'm like, is this a little immature because I'm 40? Guys, I'm about to be 41 in 8 days. And I was like, is this childish? And then I'm like, who fucking cares? I think it looks cute. Anyways, I'm going to write down interviews and I will watch a thing on how to do it. Yeah, I just don't understand why she's not here. I think unless there's an emergency, which we know that's the thing she likes to play. But I think if she should have to be here.
Thank you, Your Honor. I will attempt to reserve 5 or 10 minutes for rebuttal, and I'll try to keep my own time as well. I'm going to start. I may go a little bit out of order from the way the arguments are presented in the motion, but I'd like to start with the pleadings themselves, because that seems like the straightest line to the resolution we're seeking here. On its face, the complaint alleges various acts and conversations that Mr. Gillespie and Ms. Owens had. I'm assuming for the sake of the standard on a motion for judgment on the pleadings that all of these well-pleaded facts are true.
Oh, she is here? She just has her camera off? Oh, she's down here. Who is this then? Who's BR and CL? Down here. You're right. She is here. She is present. Has her camera off. What a pussy.
Certainly not admitted, but are true for purposes of the motion. If we do that, we find that the acts that Mr. Gillespie allegedly engaged in don't qualify for the relief that Ms. Owens is seeking under Title 36, 2153.
Hi, a little bit.
The reason for that is the statute says a person shall not in any way intimidate or coerce another person to obtain an abortion. Intimidation and coercion are terms that are not defined in the statute or really readily defined anywhere in Arizona law. But in the motion, I've pointed out 2 places where those terms appear in Title 13.
Hi, Ms. Hi,
and in both of those instances, they speak to not just persuasive speech, but truly intimidating and coercive conduct, such as threatening violence or actually engaging in acts of violence to cause another person to do something. The other example in Title 13 relates to sex trafficking. And again, the conduct that...
So he just brought up the fact that it was acts of violence to cause somebody to do something. And we know that she escalates this from abortion coercion to the fact that he told her to take the pills to he stuck his fingers in her mouth to he dislocated her jaw. And all of those would have to have taken place before this actual hearing, which she never brought up. So there were no acts of violence here. She just tells everybody that later when it doesn't go her way. Hi, Ducky. Hi, Dawn.
Prescribed there is actively threatening someone's safety or their legal standing or withholding a substance from them on which they rely physically.
Also, speaking of substance, somebody brought this up the other day, which was a great point. She wanted to accuse him of abortion coercion with abortion pills that she had obtained herself.
So all of these things are conduct more than just speech. We can imagine a scenario in which a person threatens someone else and says, "You're going to obtain an abortion today. I'm going to drive you there. And if you don't, I will hurt you." And certainly that would be intimidating or coercive. But that's not what's alleged in the complaint. In the complaint, there are many allegations relating to going on a trip, pursuing a long-term relationship, getting married, meeting with someone's
Another great point. If this case was about violence, why did she say it was coercion? Exactly.
family, etc. None of these are threats of harm. None of these are coercive in the sense that those terms are used in Title 13. The alleged behavior that seems closest to potentially being coercive is actually a promise to do something good, not something harmful like the other examples.
Oh my God, that is such a great point. Speaking of coercive, he's using positivity to coerce her to do these things. I will date you. We will grow together. We will go to Sedona. We will do all of these things. None of it is ever violent. None of it is ever threatening. He essentially coerces her to get what he wants, but in such a positive way. What a great point.
The only thing that, again, assuming all the well-pleaded facts are true and reading them in the light most favorable to the plaintiff, there is this allegation that Mr. Gillespie threatened to, quote, go public with the abortion. But as stated in the complaint, if that occurred, it occurred after it was already completed. So that behavior, that conduct, or that comment must be excluded temporarily because it couldn't have been intimidating or coercive prior to the abortion taking place. For that reason, the complaint itself simply fails to state a claim for which the court can grant relief, assuming all of its well-pleaded facts are true. Next, we've questioned whether Title 36, Section 2153 actually creates a cause of action against an individual.
Thank you, Tiff.
The statute is long and sort of meanders through various different topics. But the overwhelming majority of these subsections speak to acts and requirements of abortion providers, medical providers. The statute requires...
This is a great point from Bruce. None of these three guys have any criminal charges brought against them for anything they've done to Laura. She just goes and gets orders of protection because that's easier to do than proving crime. Great point. Interesting that she is claiming that going public is coercive, and then with Clayton threatens and indeed goes public. But also, say cheese, you have to remember in her conversations to Joe Cotchett that she sent to Greg Gillespie, she is Joe Cotchett, but she's saying that, oh, we can make this in the snap of a finger. We can make this go public, and this is a landmark case, and, you know, we'll take this to the media, also threatening then to go public with Greg.
Certain notice to be given and a timeline for that to occur, ways of documenting informed consent, certain information that a provider must give to someone before performing an abortion. None of those things speak to the conduct of a private individual. The only section that arguably could, which is this very broad subsection G, simply says a person shall not intimidate or coerce in any way any person to obtain an abortion. But then that section goes on and talks about a parent or a guardian coercing a minor child to obtain an abortion, and what occurs if the family denies financial support to the child. So even reading just that section in a vacuum without considering the other subsections of the statute suggests that the kind of conduct that's prohibited is not something that Mr. Gillespie could have engaged in. Further down.
Well, and Shawnee, I don't know if you remember too, who was it? Brittany just brought it up that Marcus probably had to take the lead because of what she said about about Woodnick and Greg Gillespie in what happened in Hoboken. She went to this judge in particular, and wrote that these two men were, she believes, orchestrated a very violent attack against her. But she doesn't even report these behaviors to police, as these would result in investigations. And you would think that if somebody left you within inches of your life and violently attacked you and put it up on the dark web, as you claim, that you would go to the police. She claimed she went to the FBI, but when Greg Woodnick got wind of this and went to the FBI and was like, I need to talk to you, the FBI was like, we have no idea what you're talking about. So you're right. An report to the police would be wonderful, but she only reports to the police when she needs to talk about people speaking about her in a way that she doesn't like. Did JFCIG stop? I don't know. I don't watch their. I don't follow them, so I don't know. Yes, he spent over $300K on all of this.
The statute, there's a mention in subsection L of a civil section filed pursuant to subsection
The date on this hearing is August 17th.
K. But subsection K references an abortion being performed without informed consent as required by this section. So again, the only section of the statute which appears that it could create a private cause of action against an individual is limited by the language of the statute to a person who's performed an abortion without informed consent. And then the statute defines in various ways what that consent looks like and what things need to be done. But none of these are conduct that a private individual could engage in unless, I guess, they performed the abortion themselves, but that's not what was alleged here.
Well, but also when we talk about informed consent, she says multiple times that she would happily have a surgical abortion. She also says multiple times that she has obtained the pills and has taken them. She said she took them wrong because she's a fucking moron. But yeah, no consent needed to be needed. She offered that up to Greg. I'll take these pills. I'll do this. I'll do that. She went to his house while he had COVID, stood outside the window, and he has a picture of her standing out the side of the window claiming to take these abortion pills on her own. He did not touch her. He was not talking to her, which is why she left the house.
So given the pleading and the conduct that's been alleged and the language of the statute itself, there is no claim here for which the court can grant relief for what I'll call abortion coercion as shorthand, because the claim itself is not really defined in the statute. Moving on and assuming for the sake of argument that there is a cause of action against a private individual under these circumstances, we've alleged that it is impossible for the court to afford complete relief with the existing parties. And the reason for that is because the statute clearly requires conduct of a medical provider who conducts an abortion, but no such provider has been joined here. And even if we read the complaint and assume all the facts true, there was no abortion procedure performed here by a third-party medical provider.
Exactly. Also, what about the medical provider that prescribed the abortion pills? Do you have that?
The acts alleged that caused an abortion under the complaint,
Little psycho.
assuming the facts are true, were acts by Ms. Owens herself.
Exactly.
All of the acts, most of the acts, as described in the motion, occurred outside of Mr. Gillespie's presence. They, according to the complaint, were done for reasons that really had nothing to do with coercion. It was, in Ms. Owens' words, because she wanted to maintain a relationship with him. And promising to do something, even if the promise is known to be false at the time it's made, is not intimidating or coercing. You could argue that it's bribery or some kind of fraud, but that's not what's been alleged here, and we're certainly not admitting that. But again, there's a categorical difference between offering to do something good and threatening to do something bad and its coercive effect on a person. In the statute, the language that's used suggests we're talking about doing something bad, not promising something. If a claim exists, then the provider themselves must be joined. If there is a provider here, then arguably it would be the person who provided the drugs that Ms. Owens used to perform the abortion. We don't know who that person is, and we certainly can't join them ourselves, nor is it the defense's obligation to do so.
No, but if I had a medical claim and I was going up against Greg, you would think that I would bring on the people who helped me obtain the abortion pills or the surgical abortion. But we don't have that. The fact that this was allowed to get any further than here is insane.
But the claim fails because the court cannot afford relief under this statute for this claim without including the provider, because that's the person who...
Look at Woodnick smiling. Look at it. I just love it. I just love that he's smiling and he's like, yeah. No points here, bitch. You ain't got no points here. I love that this is the music and he's just in a fucking suit and tie. Look at him. He's ready. He's like, we got you, bitch. You're a liar, bitch. Show us medical receipts. Oh, you don't have them. Go fuck yourself.
was required to
I
obtain
hope Greg one day
informed
just
consent.
like, I hope he stumbles across us and his porn music.
We certainly can't join them ourselves, nor is it the defense's obligation to do so. But the claim fails because the court cannot afford relief under this statute for this claim without including the provider, because that's the person who is required to obtain informed consent. That is the person who's required to document that informed consent. And arguably, Mr. Gillespie may be indemnified if there were a claim by the person who conducted this abortion without informed consent, because the duty here to do that is on the person who performs the abortion, which is not Mr. Gillespie, and it's not alleged that he's the one who performed it. All of these arguments thus far for improper joinder and the judgment on the pleadings
never
are really limited to the pleadings themselves, Your Honor. The claims I'm going to, or the motion now that I'm going to talk about is...
Also, I have to tell you, him sitting here smiling, knowing that Laura Owens is on this call, just fucking diabolical. Diabolical, daddy. Diabolical. We love it. Because, boo, Laura Owens. Tomato, tomato, hiss.
Relating to the constitutionality of the statute, so we're taking a little bit of a different approach.
All right, can we just pause there for a moment? So looking at subsection K of the statute, when I say the statute, I'm talking, of course, about 36-2153.
Yes.
So for shorthand, the court will just refer to it as the statute. So when we look at subsection K, the very first clause in it says, in addition to other remedies available under the common or statutory law of this state. So wouldn't that defeat some of your argument about having to satisfy numbers 1 through 3 of subsection K?
I don't think so, Your Honor, and hopefully I'm understanding your question correctly, but there's another claim in the complaint for intentional infliction of emotional distress. That could arguably be one of these common law remedies available that we're not moving to dismiss based on the pleadings. We may move for summary judgment on that issue if Ms. Owens complies with her disclosure requirements or doesn't. But
spoiler alert,
this statute, this subsection K, seems really to just be limiting a claim for a violation of this specific section of Title 36.
Okay. And the court agrees with you that the definitions in this statutory scheme are obviously not inclusive. So if we look at 36-2151.
Girl, you know her calling it a scheme just pissed Laura off. Scheme.
Which is entitled definitions. There certainly isn't any definition of intimidation, of coercion, or really anything similar to that the court could find.
Hi, Ken.
So that was not helpful as far as interpreting the term intimidate or coerce as used in subsection G. But it does go on to talk, and perhaps this will, it sounds like, go to what you're arguing about next, which is about the constitutionality of the statute itself. But
Hi, Boots.
by using the phrase "in any way," isn't the legislature signaling that it doesn't wish to be limited by perhaps what was included in Title 13? It sounds like perhaps you can fold that into your comments about constitutionality, but go ahead.
I will, Your Honor. And just as a preliminary point, in order to challenge the constitutionality of a statute, as the court knows, we're required to provide notice to certain government officials. We have done that. I noticed after the last hearing that we haven't filed those affidavits of service, but they have.
You know, I had this conversation with Schnitzel Ninja, and I mean, she brings up a good point that, you know, we don't ever want to have women have to prove any more than they already have to prove, whether it comes to domestic violence or assault or things like that. But in a case like this, you should have to prove with undeniable proof that you were pregnant at all, that a pregnancy ended, period. And the fact that a case like this is allowed to go forward and she never proved that A, she was pregnant, or B, that a pregnancy ended is insane.
Been filed and they're on ECR now.
Yes, we saw that. Thank you.
And so, yes, I believe that the language of the statute has numerous flaws, which we've pointed out. But the one you've just highlighted, Your Honor, is the one that really creates the biggest constitutional problem, and that's intimidate or coerce in any way any person. So we have two very broad categories here. One is the target of the intimidation or coercion could be anyone. There's nothing limiting this to a specific set of circumstances, a relationship between the two people, whether they spoke face to face, whether the speaker intended to reach that individual or even knew that that individual was pregnant. Those things, as I discussed in the motion, are all incredibly broad.
That's a great point, too. I'm not sure she had to ever prove she had an abortion. That's pretty important, right? One would think so. If you're going to court and you're trying to prove abortion coercion, where is the proof, the medical proof from the doctor that you have had an abortion and it is completed? Because that's the other thing. You can't just take pills and be like, okay, I had an abortion, I don't have a baby anymore. No, there are follow-up appointments. A doctor would provide documentation of the fact that this pregnancy has been terminated. Where is it?
Broad and vague. But then this in any way language in the statute, again, I believe that the legislature's intent was, as Your Honor has stated, to not limit intimidation or coercion to a specific definition or a specific set of words or conduct. But by using such broad language, the legislature has necessarily swept in protected conduct. So, for example, a person could make a comment to another person, I believe bringing a child into the world which was not planned or which was not in wedlock is unethical. Well, that could be coercive or intimidating, depending on the relationship between the two people or how it's said. But clearly that's protected speech.
So what I was able to find real quick, in Arizona, abortion coercion is defined as the act of intimidating, forcing, or threatening someone into undergoing an abortion against their will, which is not what happened here. She obtained the pills. She took the pills on her own. He was never in the room with her. He was never around her. This constitutes intimate partner violence or abuse, as it strips away a pregnant person of their bodily autonomy and reproductive choice. Arizona law targets abortion coercion through several specific mandates and protections. Oh, look at that. Number 2, required provider questioning. Physicians and medical providers in Arizona are legally required to ask patients seeking an abortion if they are being coerced into the procedure. Okay. Do we have the documentation for that? Do we have any doctor who noted that she was being coerced? Under Arizona law, abortions cannot be performed without the patient's voluntary and informed consent. Licensed clinic signage. Licensed abortion clinics are required to conspicuously post signs in waiting rooms and consultation rooms stating that it is unlawful to intimidate or coerce anyone into having an abortion. The state also protects individuals from being forced into an abortion by outside economic pressures. For example, if a minor refuses to have an abortion and their parents cut off financial support, the minor is still legally eligible to receive public assistance benefits. The fact that this got abortion coercion, the fact that this got so far makes me want to punch myself in the face. In any way means to me verbally, written, physically, not expanding the definition of coercion. Laura initiated the court case. She has to prove that there is a valid basis for that. Not the same as not believing women. Great point. I hope, I hope, even in the plea, I hope there's restitution for sure. Lowe has never provided verifiable proof of valuation by physician other than HCG testing and self-reported results. Great point. She is the one offering the abortion in exchange for something, right? Which would be coercion. Right. We don't even have a doctor confirm that she was pregnant, let alone coerced. Exactly. Actually, battered women would never go at their abuser this hard. If the man had done all she said, she wouldn't go after him at this hard. That she'd be too scared. Vanessa, another great point. Abortion. Guessing she was never pregnant, therefore no abortion, and thus no provider statement. Well, yeah. We know she was never pregnant. We know there was no abortion. But what I'm saying is there's so many things. There's 5 things under this law and this legal statute that should have just dismissed her case immediately. Right. They were TikTok or Pez. Hey!
Zaddy just there zaddying, fire emoji.
Earth Wool Fiber. Thank you. Thank you for that super chat. I appreciate you. Where is that? Zaddy just zaddying. Which cartoon character is it? It's just her mom. It's a head Pez dispenser of Jan. I had a procedure in January of 1991 and I still have the receipts. She is trash for weaponizing this. Bama lady, I am so sorry for your consequences, but we appreciate you for being here and sharing your story. Marcus is an established attorney with experience in front of the AZ Supreme Court as well as appellate work. He's not in training here. Certain orders should come in tandem with an investigation or charge protective orders for domestic violence and stalking. Yes. Hi, Chris Jenner. How are you? I feel bad for laughing at abortion coercion the way you say it. Oh, have you ever seen Ermagerd? I messed up on my words one day, and now that's how we say it. So there's that. Oh, my God. Thank you.
It's really just an expression of a philosophical standpoint. It's not the kind of conduct or aggressive language that we see in the Title 13 definitions of intimidation or coercion. And so the legislature may have intended to broaden those definitions by saying coercion or intimidation in any way qualifies as actionable under this statute. But just because the legislature intends to do that doesn't mean it's permissible under the law. There's plenty of case law suggesting that certain kinds of speech and behaviors are protected. Even after the recent Dobbs decision, things like the zone of privacy are still intact based on the language used in that decision. And so this language here is simply too broad for an individual to know, one, what kind of conduct is actually permitted or actually prohibited by the statute. 2, what kinds of...
I understand what he's saying. Like, it's too broad, but what proof do you have that he coerced you in any of the ways that you are saying? and not that you coerced him with the fact that if you date me, I will have this abortion. And then he's like, yeah, I'll do those things. What proof do you have that he was violent? What proof do you have that he was threatening? What proof do you have that he was physical? Oh, is it none? It's none? Okay.
Remedies or what kinds of penalties may exist for doing so. I'll touch on that point again in a second. But also what kinds of speech is permitted and which is not. And so in a way, the statute also acts as a form of prior restraint based on the content of one's speech. So it doesn't say that there can't be a conversation within a specific sort of set of parameters. The statute could say that there can't be a broad discussion of abortion in a way that incites a riot, for example, or in the context of physical violence or...
Love your hair pulled back today. Looking good, lady.
Thank you. I'm going to wear it like this more often. Y'all are so nice. Oh, and also, too, I'm watching this chat, and I'm not trying to stop this every 5 minutes. This chat today on point. You guys are making some of the best points. So good. So good. I'm trying to highlight all of them. Thank you for that super chat, Marilyn.
Intimidation or coercion. But it doesn't. It says, shall not intimidate in any way any person. So really, it's all sorts of speech. And it's almost impossible to know where the line is, where you've crossed over from suggesting or persuading a person and into intimidating or coercing. And nothing in the statute does or even could prohibit suggesting or persuading a person to do these things, because clearly that would be protected speech. Only when the speech is either accompanied by conduct or is so severe in itself that it crosses over that line into intimidation or coercion can the legislature bar that from occurring.
Also, too, I've been in one of these things, and I know that they have like a private chat where you can open it and you can go in with your attorney and type in there. So even if she might not be texting him like on his phone, but she might be just blowing up the side chat. Oh, she's got to be mad. Also, I love that head cheese is now a part of our stream. I don't...
Sorry, I skipped around a bit in the direction I was going to head here, so let me collect myself briefly.
Sure. Take your time.
Okay, so I was going to circle back around into the zone of privacy. The statute is concerning because it sweeps up protected speech. And the reason that we know some of this speech is protected is because the U.S. Supreme Court has given us certain circumstances where conversations between private individuals are given heightened protection as speech that involves a fundamental right or is within the zone of privacy set forth in the Griswold versus Connecticut decision. In that decision, the court said the First Amendment has a penumbra where privacy is protected from governmental intrusion. And this statute certainly appears to invade that space, because a person having a private conversation with their spouse or their significant other about an abortion goes directly to the kinds of relationships and the kinds of contexts in which this zone of privacy grants heightened protection to that form of speech. Things like a decision whether to bear or beget a child, which is a fundamental right.
All right. We got to give Please Go Vegan another go to trial. Go to trial. Go to trial. Go to trial, Laura Owens. Pay Greg his money. Get smoked by Woodnick. Pay Greg his money. Go to trial. Tell us your story, 'cause we believe you. We all believe you. Do it, do it. Tell your story. You're such a great writer and a blogger and content creator and TEDx person. Go to trial. Go to Hoboken.
under the U.S. Constitution.
Yes, if you haven't already, please go out and like the stream. You got to hit the little thumbs up. It'll send us everywhere.
If that is the case, and it seems to be, then this prohibition against speech would have to overcome strict scrutiny, meaning that the government would have to have a compelling interest in regulating the speech, and must also do so in a way that's narrowly tailored just to achieve that interest and not sweep up any more protected speech than necessary. So arguably, had the statute read, a person shall not intimidate or coerce another person to obtain an abortion, and didn't have this broad in any way language, it might survive strict scrutiny because there it's more narrowly tailored. But here we have arguably, and I'll concede for the sake of argument, a compelling interest to try to protect potential life. But the narrow tailoring is certainly missing here. This is about the broadest tailoring you can possibly imagine. The only way it could be broader is if the statute said a person shall not intimidate, coerce, or persuade, or suggest. There could have been additional forms of conversation that it sweeps in, but the language as it's written is extremely broad and clearly invades that zone of privacy, that sphere where individuals are permitted to communicate with one another in order to exercise and contour their fundamental rights and the relationship between them. And so to the extent that this statute acts as a prior restraint on that speech, and in this case specifically as applied, is it being attempted to be used as a cause of action for non-intimidating, non-coercive speech, it is unconstitutionally broad and vague. There's no way that Mr. Gillespie could have known what conduct was permitted or that this conduct specifically was prohibited if we read the statute to include what is alleged in the complaint. Your Honor, if you have additional questions at this time, I'd be happy to address them, but otherwise I will reserve the balance for rebuttal.
All right. At this time, the court doesn't have further questions. We'll hear from plaintiff's counsel.
Thank you, Your Honor.
Yes, plaintiff's counsel.
Your Honor, I would like to start where the defense started, with the allegations in the complaint and whether under 12b-6 that is sufficient to state a cause of action here. In reviewing the complaint, the specific paragraphs and the attachments to it, it is sufficient, Your Honor, to state a cause of action. In looking at, for example, paragraph 11, the allegation is that Mr. Gillespie said he did not want a bastard child. He would have no involvement in its life, nor paid child support. So he'd withhold.
Hold on, I'm going to let him finish his thought.
Any kind of financial support for the child.
Okay. I don't want a bastard child. That's an opinion. Okay? That's just an opinion. That's just how he feels. I don't want a bastard child. Okay, great. I don't want a sub sandwich right now. That's just, it just is. Withholding any kind of financial support. Okay. That's also, I'll give you that argument. However, you can only have that argument if you don't have anything to support the fact that Laura then went and was like, well, I'll just go to the courts to get it. So it doesn't matter. That argument is moot. He could be like, I'm not giving you any financial support, because she was like, well, I'm going to go to court and fucking get it anyways. So what's the point? So he said it. He can say whatever the fuck he wants. Ugh.
Paragraph 14. He would refuse to contribute to the relationship until she terminated the pregnancy. Paragraph 35.
Hi, Wendy.
He threatened to call law enforcement on her if she hesitated to get an abortion. Okay.
He tried everything. He tried not talking to her. He tried talking to her mean. He tried talking to her nice. None of it worked. None of it worked. She harassed this man into the fucking ground. And he was like, I'm going to call the police if you don't get a fucking abortion. Fine. She still went and obtained the pills herself, went to the doctor without him. Hello?
Look at one of the attachments to the complaint. When I was reviewing the filed documents in the court's file, it was from part 2, I believe page 7 on the right side. And in a text message, it said, by Mr. Gillespie, if I don't get a say, then you don't get money from me. And he made it clear in that context that he was in favor of abortion.
Yeah, okay, that's his right. That's his right to be in favor of abortion. He does not want to have a child with her. Yeah. Ugh. He never talked to me. Leave Laura alone. Fake Jam Black. Get out of here, fake Jam Black.
So these statements, Your Honor, do constitute coercion.
We did.
Now, defendant's counsel is correct. There is no definition in the statute of intimidation or coercion. Courts have long held that even if there is not a definition,
that's the thing. You know what? I really wish Marcus would have brought that up. Parapet, that's such a great point. But I wish Marcus would have brought that up, that she said she would have an abortion if he did X, Y, and Z. Is that not coercion?
Then the court looks to what is the normal definition of these phrases in normal life. And so if you look at, for example, the Merriam-Webster dictionary, which is often cited, the definition of coercion is the use of express or implied threats of violence or reprisal, such as discharge from employment, or other intimidating behavior that puts a person in fear of the consequences in order to compel that person to act against his or her will.
Again, this would also be a legitimate argument in my eyes. I'm not a judge, but this would also be a legitimate argument to me had she seen him more than 2 times. She had only seen him in person twice. They were intimate. That was it. He never saw her again, except for the fact of when she was standing outside of his window. Come to my window. Ugh. Right, and then Laura was threatening his employment. Exactly.
Now, I do want to be clear that while my colleague has cited various criminal statutes as what obviously would qualify as intimidation or coercion, that is obviously the highest and most strict standard. This is a civil case. We're not in a criminal case. And so the standards from dictionaries and other items that are...
This is a good point. They're arguing about the statute, not logic. That's why this is frustrating. Okay. Okay, Martine. Way to be smart.
are common to people do apply, as well as these criminal standards. And one case that I would cite to Your Honor, as far as when lack of a dictionary definition does not compel the statute to be void for vagueness or otherwise unenforceable.
Also, I love the idea that she's taking him to court for abortion coercion and is talking about how she feared for her life. But when she literally thought he was dead, so she had to go to his house, she never called 911. It's my favorite.
Is Franklin v. Clement, 240 Arizona 587. And in that case, Your Honor, the court specifically discussed the void for vagueness doctrine, but it goes on to state that, if I can find it, 1 second here, Your Honor. As long as a statute allows a person of ordinary intelligence to reasonably understand what is prohibited, it will not be considered unconstitutionally vague, even if it is susceptible of different interpretations. And the court was discussing what under the influence means in that case, which was not defined. And so the fact that it's not specifically defined in the statute is not fatal. But, Your Honor, the specific allegations in the complaint are enough for the court, as the court held in its initial 12b6 order regarding the first motion to dismiss, for a jury to find that believing and taking all inferences in favor of the allegations of the complaint, a jury could find that it is proved.
Why are we arguing any of this when the judge has no proof on her desk that an abortion took place? That should be the first question. The first question from the judge was, when did the abortion take place and what medical documentation do we have that says the pregnancy has been terminated, before we move through this argument? Holy shit.
Now, as far as the statute and whether or not the statute allows a claim for under paragraph G, Your Honor, I believe that subsection K, or paragraph K, however you would like to refer to it, of the statute, and of course I'm referring to the statute in the same way the court did. I think another key phrase, other than the one that the court pointed out, is...
I understand that the judge knew to remove logic before this, but my question is in a court of law, it is not about emotions. It is about facts. Hi, 99 Problems. And we have no facts, none, zero, that she obtained an abortion. None. That should be the first fact. This abortion happened because of this. If you don't have an abortion, you don't have an abortion coercion case. What are we doing?
Any of the following may file a civil action to obtain appropriate leave for a violation of this section. And it doesn't refer to subsection A, paragraph A alone. It refers to this section. And so that includes paragraph G, which is a person, you know. It includes paragraph I, which also indicates a person.
Proof comes later. They have to all assume all facts are true to establish there is a case or a cause, which is insane. I mean, there should be facts in the beginning to establish that there's a cause, because all of this would have been squashed immediately.
Person, which that allegation is not present, Your Honor, but to the extent that the defense indicated that this action could only be brought against a physician, it's clear that throughout the statute it references what a physician cannot do, what an individual cannot do in subsection E, what a person cannot do in subsection F, G, and I, and what an abortion clinic shall do in subsection H. So when you look at K, and that it is for a relief of this section, not specific to any certain subsection.
Say cheese. Court of law is about facts and law. Her affidavit allows the filing. They are arguing that you don't even need to get to the facts because she hasn't stated a case under the law. Oh. Look at us learning today.
That has to include all of these, including G. And one of the individuals that is able to bring an action is a woman on whom an abortion has been performed without her informed consent. Now, another issue of statutory interpretation that I think is important for the court, because as the court knows, the reason for statutory interpretation is to effectuate the intent of the legislature. as indicated throughout the statute.
I see. Your complaint is why there are vexatious, right? Litigant lists. The law assumes you don't bring frivolous cases until proven wrong, right? Okay, I'm getting it.
And not specifically only one subsection, is so looking at the different types of individuals specifically listed, a woman, a father who is married, not just any father, but who is also married to the woman, and then a maternal grandparent. I find it interesting, Your Honor, that they can bring an action for a violation of this section, but it only references informed consent with regards to the woman's ability to bring an action. In number 2, the father of the unborn child, there is absolutely nothing in that that says that it is only if there was informed consent. And one thing that the legislature and another canon of statutory interpretation is that we can't interpret statutes to that would give an absurd result. And so if the court were to
The only absurd result is the fact that we're all sitting here watching this right now.
find that there was no ability to bring a cause of action in this case because the woman's ability is limited to a condition precedent that there was not informed consent, but a father could bring an action under G that is married. It goes to an absurd result, Your Honor. And so that
I don't know if it can only be, I don't know about Megan Fox saying that, but one of the things that is required to prove it is the fact that there is required provider questioning. So physical and medical providers in Arizona are legally required to ask patients seeking an abortion if they are being coerced in the procedure, which means there would be some sort of documentation that this was happening. And there's none.
That's why in looking at the interpretation and looking at the broad public policy of this statute, which is to protect a woman's right to be informed about her decision and not to be coerced.
Look, I know what you guys are going to tell me, but we just have to get through this. Look at the text messages. Look at the text messages.
Into making that decision, limiting her right to bring a cause of
Bye, Stevie. I hope it goes well. Peace. May Dave be with you.
action to only a specific set of circumstances, whereas the father has an unfettered right, a married father, would lead to an absurd result. And I think if you continue to look at subsection L, and I know I'm going into a lot of detail because obviously I wasn't able to file a response here, and I want to make sure that all the points are covered, Your Honor. But
Marcus looks like he's going to kill somebody right now.
looking at subsection L, I think also lends to that interpretation.
Hi, Wings.
That this is not only against physicians, this is against any person, just like Mr. Gillespie. And if you look at subsection L1, again, you're able to bring a cause of action for money damages for all psychological, emotional, and physical injuries resulting from the violation of this section. Not just the violation of subsection A.
Hold on a second.
It's for all psychological, emotional, and physical injuries.
Okay, psychological, emotional, and physical. I had only seen the physical, and I'm like, there are no physical damages.
Resulting from the violation of this section. Not just the violation of subsection A for informed consent, but of...
I don't ever want to say anything bad against the lawyers that represent her, especially when they withdraw, because it's like they have to assume that what she was saying is true in the beginning, right? They have to assume that their client is being honest. And obviously, as they go forth and they do a little bit more research in this case, they're like, well, all right, never mind. And they withdraw from the case. So, I mean, he's just doing his job. I don't have any problem with that. And especially because he withdraws, I get it.
violation of this section in whole. And so if the court were to
Yeah, they're
interpret
essentially being held
this
hostage.
contract
That's a great point.
or the statute, pardon me, as precluding this claim, I think that would be against the public policy in which this was enacted. In that vein, the motion cited the doctrine of expressio unius as, and I might be butchering that pronunciation, Your Honor, but as that it should be applied in this case to prohibit this claim.
Somebody asked in my comments the other day when, why still shit on Laura Owens if, something about, I think it was Dave Neal. Somebody said that she was selling her horses to get mental help. And they're like, why are you continuing to shit on Laura Owens? And I don't, I'm not going to ever go back and forth with people in the comments. I think people, are allowed to have their opinions about the things that I say and the things that I do. Laura Owens can get, obviously she's a very sick person. She can get all the help in the world. Until she shows remorse, genuine remorse, and pays these families and these men back, I will not let up. She has done nothing but double down, triple down, quadruple down on her claims, even after being charged with fraud and perjury. It doesn't matter how much mental help you get. Yes, she's a sick individual. We know that. But she continues to drag these men through the mud. She continues to try to ruin Michael Maricini's life. And until she lets go, I will not relent. That's why I continue to shit on this woman. Because she continues to go and use social media, and she uses her Instagram or she uses her Medium blogs as a way to continue her narrative. So that's why I'm going to do it. Sorry.
One thing that was not mentioned in that is this doctrine is not to be applied where its application contradicts the general meaning of the statute or state public policy. And so my client's position is that if the court were to apply it to limit the claim herein, as the defendants are alleging, it would contradict the state's public policy here to protect a woman's right to make this decision without coercion and to be informed about it. And this language comes.
I have to tell you, I'm not trying to be mean here, but I don't understand what the argument is. Like, you're right. I very clearly understood what Greg's lawyer was arguing. I don't understand what's happening here.
Directly from Southwest Iron and Steel Industries, Inc. v. State, 123 Arizona 78, which was cited in the motion by the defendants. And so for those reasons, Your Honor, I believe the legislature specifically intended to allow this type of a claim to go forward.
Well, so
even the judge is like, oh, is it you? No thanks. Who said that? Yeah, somebody was defending me in those comments, and I was like, they got it.
Argument, counsel, is that your client is not one of the three categories of people under subsection.
Flux, listen, I've been meaning to message you. When I think we should cover the Alex Murdaugh trial together, and we should go head to head since you want to be defense and I could be prosecution. I think it'll be great. Hear me out.
Okay, 1, 2, or 3. But that essentially the legislature erred when it had included the phrase.
The man talking is Laura Owens' lawyer.
Without her informed consent in subsection K1. Is that accurate?
Let me clarify that, Your Honor. Thank you for that question. My position is that within this doctrine, right, within K1, a woman on whom an
I have to tell you, Jack, I went through the court system last year and I was only in it for a couple of months. To want to continue to go to court is crazy work. Crazy work.
abortion has been performed without her informed consent is the fact that there has to be consent, period. And if you look at the heading of this section is informed consent. And then it goes on to say requirements, information, website, signage, violation, civil relief. But at a base level, my client didn't give consent to the abortion because it was overcome by the coercion of the defendant. And so that is how the court should interpret that specific provision in K1 in finding that my client is entitled to bring the cause of action as an individual under K1. And again, looking at the absurdity of it, if she wasn't able to, as a single woman, so there was no father of the unborn child that was married to the mother at the time she received the abortion. So the legislature didn't intend to penalize single women under this statute and leave them out of any ability to bring a violation of subsection G or I or subsection E, which in looking at the motion, Your Honor, the defendants indicated that Mr. Gillespie could be liable for, I believe it was 36-2155, which is
Well, that's the thing. Laura offered to have the abortion. How can that be coercion? Laura offered to have the abortion if he dated her, which is coercion. My brain, it hurts. I need a drink.
obviously as a separate section, but it is the exact same language as under E. The very same phrase, an individual who is not a physician shall not perform a surgical abortion. It's just in a separate section, and that separate section does not contain a specific civil cause of action. Does that answer your question, Your Honor?
Yes, thank you.
It doesn't answer mine because I don't know what the fuck we're talking about at this point. There will be no logic here. None.
Well, with that, Your Honor, I'd like to move towards the constitutionality piece of the motion.
Panic chugging.
The first thing I think that needs to be noted is the courts have long held there is a strong presumption that a statute
He hacked her uterus and deleted the babies, is what happened.
is constitutional. So the defendants start on an uphill battle in bringing an action
Laura, is that
claiming
you?
that this statute is unconstitutional.
Right.
There is a presumption that requires the challenging party to establish that unconstitutionality, and any doubts are resolved in favor of upholding the statute. And that is, it's throughout various cases.
Marcus is this gentleman right here who has become aggressively close to the camera for no reason. But him and Woodnick are on Greg's team. And this is Laura's attorney. And this is the judge. All of a sudden, Marcus is just like, like he's looking directly into the birth canal. He's in there.
Your Honor, if there is a specific case I'd cite to, it'd be Ramirez v. Health Partners of Southern Arizona, 193 Arizona 325. But getting to the void for vagueness argument, as I mentioned earlier, the test is whether the statute gives a reasonable person of ordinary intelligence a reasonable opportunity to know what is prohibited. And so just because it might be hard to tell exactly what side of the line some speech is on,
Hi, Mooncat.
does not mean that the statute is vague, unconstitutionally vague.
Bye, Vanessa. Marcus is all of us. I know he's trying to read something, but he's just like, he's like, where are the twins?
And another general rule of law that courts are to apply is courts are to interpret these statutes in a manner that is constitutional.
She's just got little stick figures where she's like, Jack the judge. She's like, okay, this one's got glasses, right? And he's got like this kind of crazy hair. He's got like a mustache and a little beard. All right, this is Woodnick. This other one, he's got some hair like this. Here's his head. And he's got like a full beard. This is just the judge right now. She's like
So when the motion tries to intimate that this statute is too overbroad because it really is according to the subjective feeling of the person, whether or not they were intimidated or whether
these are actually all Greg's, but they have AI face filters on. This is just all Greg Gillespie.
or not they were coerced. That's not what the statute says, and that's not in the vein that the court should interpret it, because that's not the way that a reasonable person of ordinary intelligence would interpret it, because that's adding words to the statute. That would be saying that the statute indicated a person shall not make another person feel as if they are intimidated or coerced. And that's definitely not what this statute says. And so, Your Honor, the void for vagueness argument should be denied. Intimidate, coerce are terms that are used throughout the statutes in Arizona, Department of Transportation statutes, various places. And
that's a good question. Hold on one second and let's see. Does this lawyer know about Hoboken yet? Or not the lawyer, the I can't say it now regularly because I Hoboken. Hold on. It was August 4th, but it was wrong because it was August. Hold on. No, is it? Where is it? Okay, so it was here August 1st. So yes, they all know about Hoboken right now. Everybody in here knows about Hoboken. Hoboken. I don't know why I say it like that now.
and are common terms that have been used for years. So the case Franklin v. Clement defined.
All right. I grant your motion to turn him up a little bit. I could probably put 1.5 and we'll be fine.
Talked about, as I indicated, what under the influence means.
Okay, never mind. 1.25 speed.
And the court indicated that under the influence has a commonly understood meaning. And although different people may evaluate under the influence in different ways, that by itself does not make it void for vagueness. And so in this case.
All right, I just want to ask you, though, it's kind of the same question that I asked opposing counsel, but just turned towards you. Here, though, on subsection G, we have shall not intimidate or coerce in any way any person, which seems a little bit broader than just your common. If we look it up in the dictionary, we're talking about in any way. So it's somewhat broader, I think, than the limited under the influence, I think, as a kind of a common parlance understanding. Here we have intimidate or coerce in any way. So what's your response to a broadness concern there?
Sure. Thank you, Your Honor. I believe that so the start of that goes back to, well, what is in any way modifying? And so intimidating or coercing. So I think that goes to statements, behavior, threats. How are you performing it? I think the legislature wanted to be sure that, hey, this isn't just threats, statements to somebody. This is also actions. So if you, for example, if someone leans into you quickly, that could be seen as threatening while you're saying something to get them to get an abortion. But
She's a woman. I'm confident she knows what threatening behavior looks like.
I think the legislature just didn't want to confine it to only words or only threats of physical harm, only threats of physical violence, things
All right,
like
so
that.
let me ask you then. Back in a past life, when I was a federal prosecutor, I used to prosecute bank robbery, and we had a guy.
Can we talk more about that? Hell yeah. Fuck this case. Let's talk about you being a federal prosecutor and bank robbery. I want to hear that shit.
Who, I promise I'm getting to my point quickly here. We had a bank robber who was convicted of bank robbery, and under the federal bank robbery statutes, it defined robbery as intimidating someone into giving you money. So his second time around, he was convicted. He goes back out and he goes to a bank, and this time he goes into the bank and he says, please. And he smiles at the teller. And the teller gives him the money. So you can guess what his defense is. I didn't intimidate anybody. I walked in, I asked for the money, and they gave it to me. It wasn't robbery. So in that case, the court struggled with what is intimidation? How do we deal with it? And similarly in this context, so if someone talks to another individual who...
Also, how is it intimidation if he's never threatened her and he hasn't been with her in person? The only thing he has said, and I know they're just arguing case law to get it to the point right now, but it's so aggravating how it gets past this.
May or may not be pregnant, and says, have you thought about getting an abortion? It's a question. Have you thought about going through with it? And they smile and they're polite. Are they intimidating? Are they coercing? And how do we answer that in the context of this statute?
Sure. Thank you, Your Honor. I think it goes back to that reasonable person standard, right? And as I indicated, a court is to interpret a statute.
Okay, you lost me at reasonable person. That it goes back to that reasonable person's standard. So now, I understand that it's broad, but now we just get to make shit up and waste the court's time.
Statute, so such that it is constitutional. A court is able to say no, that specific conduct it would be unconstitutional if that were to be applied and that were to be a violation. So a court can set that aside and focus on the specific conduct that would be a violation of the statute.
Which is what? What is the behavior?
And so, for example, the court indicated that a person who may or may not be pregnant, the question is whether they could be intimidated or coerced to obtain an abortion. I think that phrase, to obtain an abortion, should be construed such that, well, they're pregnant, because it wouldn't matter if they are not pregnant. If it was conduct or statements, intimidating or coercion conduct or statements to a male, I think the court can interpret it such that, well, that can't violate this statute. Because
is it not intimidating that she goes to his house? Is it not intimidating that she texts him 47,000 times a day? Is it not intimidating that she calls his HR department and goes after his job? Oh, she says may or may not be pregnant. She knows.
They are not pregnant. And the conduct has to specifically be to obtain an abortion. So let me
flip it around. What if a pregnant, there's a couple and they're pregnant, and the woman who's pregnant is the one who is intimidating or coercing the man to get an abortion. So she doesn't want to carry the pregnancy, but he does.
But what if he doesn't want to have the pregnancy and she's like, I'm doing it just to punish you, not because I actually want to be a mother? What about that?
So it sounds like he would have a cause of action under the statute. Is that right?
I don't believe so, Your Honor, because it would have to be the way I read it, and the way I think the court should interpret it, right? Because the court's supposed to interpret it such that it's constitutional, is that the person has to be pregnant in order to for someone to coerce them or intimidate them to obtain an abortion. So, for example, the motion indicated that, well, you could do that to yourself and potentially have a cause of action. One thing I think that goes without that should be mentioned is this isn't a criminal statute, right? So
Oh, yes.
you'd have to get damages. So if you intimidated yourself, you can't have damages or sue yourself. That's not a cause of action.
Oh, I bet you if she could, she would. She's like, damn it. I can't believe I lost all of this. I'm going to start suing myself.
So that can be set aside. But because a male, assuming they're not pregnant, and I know that conversations about that come up sometimes these days, but so coercing or intimidating them to obtain an abortion, I think needs to be construed by the court such that that individual that is the victim of it is pregnant and would be the one to obtain an abortion themselves.
Okay. Thank you.
Thank you, Your Honor. The final thing that I would mention, Your Honor, is as far as joining the claim of failure to join a necessary party, there is nothing in this lawsuit that prohibits my client. A claim against the physician and a claim against Mr. Gillespie are totally separate. The statutes are separate. The damages are separate. There would be nothing, and I'm not saying that this happened at all in any way, if there was a settlement. Does that mean that we have to bring him into this action because without the physician's presence, Mr. Gillespie, there can't be complete relief? Well, they're separate causes of action. And so the physician, whether it's a he or a she, and I'm totally unaware of who it is, but they are not necessary for my client to obtain relief against Mr. Gillespie because.
Yes, they are. Yes, they are. Because if there's no abortion, there's no abortion coercion. There's no emotional and psychological damages. They are all connected. Oh my God, my brain.
Because the claims against him are not the claims against the physician. And for those reasons, Your Honor, my client would ask the court to deny the motion to dismiss.
All right, thank you. Just a moment here. Let me look at my notes and see if there's any other question that the court may have.
Okay, before they go back, I have to go to the bathroom so bad, and I don't want to interrupt Zaddy. So take this minute to yourselves. I'll be right back. Speed pee. And I am back. Hello. Okay. Yes, quick break. All right, let me see. What do we got? I can't with this argument that actually happened to my brother-in-law. His girlfriend was pregnant, and he was so excited, and she said, if you don't propose within 2 weeks, I'm getting an abortion, and she did. Oh, wow. I am so sorry. I love Bloodworth. I was like, why do I have like a secret crush on Bloodworth? And then Emily D. Baker posted on her story that she met him and he was in regular clothes. And I'm like, oh, yeah, no, I have a crush on him. Like, So if the person has to be pregnant, then she should have to provide real proof she was. We would think so. No doctor needed. Well, then I'm pregnant and I got an abortion and Bacon Bears coerced me into it. So please give me all her money. Okay, thanks. Bye. Oh my God. Bathroom coercion right there. Talk amongst yourselves. Talk amongst yourselves. Talk amongst yourselves. I'm verklempt. His argument fails also because the threat was withdrawal of relationship and financial support. If she doesn't have the abortion because breaking up is not a threat and she made more money. Let's see. It's 6:30 p.m. It's time for a sandwich. Ooh, what kind of sandwich? And also, where are you that it's 6:30? She may really have thought she was bringing some landmark case, didn't she? Ugh, God. Herbal teas like cranberry, nettle, horsetail, and peppermint can support bladder health by reducing inflammation, promoting urinary flow, and soothing discomfort. Thank you, Jen. This is not sponsored. Oh, the bitch is bankrupt. Everyone, regardless of orientation, has a crush on BB. On me? No, on Bloodworth. Wait. People call me BB. Be careful. Brad Bloodworth. I was like, me? Okay, girl. Okay. Let's go. I love the way Americans say herbal. How do you say it? Herbal? How would you say it? How do I don't even want to. I was about to do like a fake English accent. Herbal. I don't know. How do you say it? I don't know. I'm lurking across the pond. Oh my God. And it's not even 7 in the morning. Taking this moment to light some candles and grab a beverage for the date with Zaddy. I have my candle right here. I have a crush on bacon. I have a crush on all of you. Bo. Is that I don't know. How do you say it? Also, my accent, my Midwestern accent is so bad. Herbal. Herbal. Yeah, we say herbal. 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 I don't know. Yeah. Also, BB is a broken baker. Yeah, I can't bake at all. But yeah, my Midwestern accent is so bad and my A's are so sharp and it's bad. Anyways, okay. Back to regular programming. Herb.
Let me just circle back to, you answered the question, but I just want to make sure I understand. So under subsection B, it says a person shall not intimidate or coerce in any way any person to obtain an abortion. So the to obtain an abortion, your argument is that that means that the hearer of the coercive or intimidating speech, or you said it could be an action because it's in any way, that the victim, if you will, is it needs to be pregnant.
That's correct, Your Honor.
Okay. And that is because of the phrase to obtain an abortion.
Correct, Your Honor.
All right. So could somebody...
Wisconsin cheese? Somebody just dropped something big upstairs. Wisconsin. I don't say it like that. Wisconsin. Or if I'm really saying it, Wisconsin cheese.
So under your interpretation of the statute, then you could not have a situation then where, say you have a pregnant couple and say the father has an aunt and the aunt is really coming.
I just want to know why we're doing hypotheticals. I mean, obviously this is so broad, you can just make up whatever you want. Oregano. Oregano. Ask me how I say Oregon. Oregon. Anyways, why are we giving hypotheticals? Like, I just don't understand. The law is so broad, we can just throw anything out there. So, like, she's like, let's just say you had, no, let's just say you have a woman claiming that she was coerced to get an abortion and she was never pregnant. Let's say that. Let's say that. There's a hypothetical for you.
Down on the father. This mom needs to have an abortion. That needs to happen. She never talks to the mom. She only talks to the dad. Does the dad have a right of action under G? Earlier you said no. Just want to make sure I understand, because under G it says in any way. Could he sue his aunt?
I don't believe that there would be a right to a cause of action for that, Your Honor.
Okay.
I think that would be outside of the scope and outside of what the legislature was looking to.
I think they believed it because it was in some of the motions and some of the language that Greg Woodnick used inside of his motions. So he had said, like, this is nonsense, and that, you know, if she actually is pregnant, I don't think he actually believed that she was pregnant. I don't think either of them did.
Do here with this statute.
Okay. And that is because he couldn't himself obtain an abortion?
I think so.
Is that your basis for that?
Yes, Your Honor.
Okay. All right. Thank you. All right. So we'll hear if there's any rebuttal or reply. I see that you have 10 minutes remaining.
Thank you, Your Honor. I'm going to start with the reference made to 36-2155. I think Mr. O'Dwyer said that we'd envisioned that there could have been a claim against Mr. Gillespie for a violation of that statute, but that statute pertains only to a surgical abortion, which is not alleged, and that's one of the few terms in this statutory scheme that actually has been defined for us. So clearly that's just not the case.
I know what you guys are trying to do. Would you like some, you know what, Jack? Would you like some herbs like oregano on your pasta? I know that just made your ears bleed. Aluminum schedule filet. But I know they say aluminium because I watched Gordon Ramsay.
I'm going to go back to the vagueness point because I think the court stumbled on, and Mr. O'Dwyer discussed, kind of an interesting quirk in this statute. If you look at subsections K1 and K2,
Please stop. I'm sorry. This is the way I am. That pasta. Oh, God. Please stop. Oh, you guys.
if we're going to read the statute exactly as it's written, which seems to be what Mr. O'Dwyer would ask the court to do, then there is a difference between a woman on whom an abortion has been performed and the father of an unborn child if he was married to the mother at the time she received the abortion.
Hi, Toadette.
Because K1 specifically says a woman on whom an abortion has been performed without her informed consent may file a civil action to obtain relief. And then it doesn't say anything about informed consent in K2. I don't think the court can read that section without the informed consent component, without making this entire statute superfluous, absurd, insert adjective here. The abortion in K2.
That's what I like. I want to hear you at normal speed. Insert adjective here.
It means an abortion without informed consent. If an abortion is performed with informed consent, then certainly the father of the unborn child could not sue the person who conducted it. Nothing in the statute suggests that the informed consent must also come from the father of the child or the grandparent of a child if the mother was under 18. The operative language in this statute is that informed consent. That's what the entire statutory scheme is built around. And if you look in the rest of Title 36, informed consent is referenced even in the general provision title of 2153, 2158, 2156, So this common thread of needing informed consent exists throughout this entire scheme.
Bye, Parapet.
And so again, the statute, when read through this lens of informed consent, imposes numerous duties on the person who provides or conducts the abortion. It says an abortion shall not be performed or induced without the voluntary and informed consent of the woman on whom the abortion is to be performed. That's in subsection A of 2153. And then I'm not going to count them on the record, but there are over a dozen, maybe 24 different provisions, all relating to the duties of the person who performs the abortion. And then if you go to the definition statute, the surgical...
It's still early. Laura, are you here?
I'm always here. I'm always lurking.
Abortion requires termination of a clinically diagnosable pregnancy. Medical abortion is the use of a medication, drug, or other substance. Both of those things require a medical provider. They're the one who has the duty to ensure that informed consent is given. And so reading the statute to have a couple dozen provisions about medical providers and informed consent and all the various requirements and duties they have and some of the consequences that they may face for failing to do so, such as J, a physician who knowingly violates a section, commits an act of unprofessional conduct. But then reading only subsection G, not to apply to that circumstance, or not only to that circumstance, but to broadly apply to any private individual doesn't make sense. It's like we're now reading one sentence of this statute to have a completely
Great point, Shawnee. Informed consent means that the person is aware of the consequences of the procedure, its effects and possible side effects, and the risks. She knew all of that. Well, except where to put the pills, because she didn't know. Because...
Who puts tablets in their vagina?
different scope and meaning and purpose and policy basis than the rest of it. That's an absurd reading. Conversely, the court could read that subsection only to apply to a person who performs the abortion without informed consent and avoid that problem. With respect to the in any way language which the court pointed out during Mr. O'Dwyer's presentation, Mr. O'Dwyer responded that in any way is intended to modify, intimidate, or coerce, and broaden what kind of conduct or speech is intimidation or coercion. If that was the case, then the legislature should simply have wrote, a person shall not intimidate or coerce any person to obtain an abortion. Because intimidate and coerce are not defined in the statutory scheme, that would be sufficiently broad on its own. But looping in this in any way language, which is far more broad, as the court has pointed out, brings in all sorts of unique problems that I've pointed out create First Amendment issues. Coercion or intimidation in any way. Does the person speaking need to know that the person who receives the abortion heard them?
I love this chat so much. God, I love this chat.
Do they need to have any kind of relationship with that person? If it's a reasonable person standard, which doesn't appear in the statute, then the answer, I think, would be no. But the statute is written to incorporate any kind of intimidation or coercion. So a public figure could go on television or during a political debate, for example, and say, I believe that any person who bears a child outside of wedlock is committing child abuse, and they should instead get abortion. Certainly some listeners would find that intimidating because it's coming from a public figure, possibly even coercive if they think that public figure carries the force of law. But that would...
And here's where she writes down in her notebook, and she's like, oh, he said public figure, huh? Dear diary, my next victim, public figure. Yes. Very intimidating.
Clearly be protected speech. I don't think that's questionable or even an issue for discussion. So we can't read the language of the statute to incorporate any kind of intimidation or coercion without doing damage to the First Amendment and to protected speech. Alternatively, the court can read that section as unconstitutional if applied in that manner, and then we don't have the issue. Lastly, I'd like to go back to the complaint itself, because Mr. O'Dwyer pointed out a couple of sections that he felt are intimidating or coercive. One of those was that Mr. Gillespie said he did not want a bastard child and would have no involvement in the life or pay child support. That's in section 11 of the complaint. But then in section 14 of the complaint, it says plaintiff indicated to defendant she did not expect him to be involved in the rearing and support of the child and did not need to speak with her again if that is
Look at that. Laura Owens arguing against herself again.
what he desired. So if that was potentially intimidating or coercive language, it didn't work because the plaintiff alleges that despite those things that she did not expect from him, she proceeded. So on the face of the pleadings, assuming these facts are true, the claim fails. Furthermore, in section 39, there was a reference to, I'm sorry, I wrote the wrong number down. 35. Defendant used verbally and emotionally abusive manipulations, even threatening to call the police if she hesitated in terminating the pregnancy. This was alleged by Mr. O'Dwyer as another potentially coercive or intimidating act. But if you read the prior sections of the complaint, in section 18, on July 28, 2021, plaintiff administered the first pill. On July 29th, she administered the second pill.
Say it. Say it. Say it. Say it.
Who puts pills in their vagina?
On July 31st, she correctly administered the second pill again. And so by
Look at his face. He's like,
the time we reached this allegation that he threatened to call the police if Miss Owens hesitated, she had already performed, induced, conducted, whatever verb you want to use. It had already happened. So that could not be coercive behavior that caused her to obtain an abortion. It was done. The things that happened prior, as pointed out in the motion and in argument, were promises to do things at most. We could have a relationship. I want to meet your family. Maybe in the future we could have a child. We're going to go on a trip, etc. Promises to do things are not intimidating or coercion. No matter what definition you choose for those terms, that ain't it. There needs to be something that causes a person to act.
this motherfucker just said, that ain't it. That ain't it. That ain't it. I think Bacon just likes talking about vajayjays. Who doesn't? Who doesn't?
Against their will. And that's not what occurred here on the face of the complaint. And so regardless of whether the court finds the statute to be constitutional or not, the complaint does not state a claim for which relief can be granted, even if we assume all of the pleaded facts are true. And for that reason, this abortion coercion claim, which is shorthand, I don't know how else to call it, must be dismissed.
Yes.
All right, thank you.
Yes.
The court will take the matter under advisement and issue a rule.
As people are all talking about administering things wrong, I would hate to see Lo use an inhaler. Speaking of intimidation, doesn't threatening to tell your employer you refuse to date her, then telling your employer you refuse to date her count as intimidation? Yes. Yes. Ugh.
As soon as it is able to do so. We do have 60 days from today's date. We always endeavor to get it out just as soon as we can, and well under the 60 days. But we obviously want to, as we always do, reread everything that's been filed, and then also continue with our case law research. So we will do that. So thank you, counsel, for your presentations this afternoon. I appreciate it very much. Anything else today from plaintiff?
No, thank you, Your Honor.
All right. From defense?
Very briefly, Your Honor, I know there's been some discussion and filings in this case about discovery and disclosure disputes. My hope is that now that Mr. O'Dwyer is involved, we can proceed with those things.
Yeah, like maybe she could hand over evidence.
But what is the court's preference if there is a discovery dispute? Do you prefer a motion is filed or that we call your JA, or how do you want us to do that if the issues are not resolved?
File a 2060 joint statement and we'll address it.
Okay, thank you.
Thank you. All right, anything else from defense then?
No, Your Honor.
Okay. All right, thank you, everyone. Please take care, be well, and we'll be adjourned.
Thank you, Your Honor.
All right, and that's that. So let's see what else we got. Oh, thanks. Okay. Poot. Oh, who the hell said stop shitting on low? Gina. Oh, God. She can't figure out a tablet. She can't figure out where her clothes go. Hello, I'm 13 minutes behind in stream, catching up. Hi, Michelle. All right. Let's then go here. We will go back. So then, let's see what we got. Then we got Laura files a notice of appearance, now being represented by Kyle O'Dwyer. Oh no, sorry, we already did that. So we just did the hearing that was on August 17th. By October. Gonna go scream into a pillow now. And once again, no finality. Exactly. October 12th, Greg's motion to dismiss for judgment on the pleadings of plaintiff's abortion coercion claim is granted, which is a huge blow to Laura. We love to see it. Let's read this paperwork here. It's 8 pages. Pending before the court is defendant's motion to dismiss for judgment on the pleadings of plaintiff's abortion coercion claim, filed February 15th of 2022, following an extension of time for a response. The motion was fully briefed and oral argument occurred. Having considered the parties' filings, presentations at oral argument, and applicable law and rules, the court enters the following order. Plaintiff, Laura Owens, alleged in her complaint that defendant employed false promises and verbal and emotional abuse to coerce plaintiff into getting an abortion. In the instant motion, defendant moved to dismiss plaintiff's claim regarding coercion of abortion under Rule 12 of the Arizona Rules of Civil Procedure. Defendant further moved for judgment on the pleadings as to the same claim under Rule 12. In doing so, Greg challenged the constitutionality of the statute on whether plaintiff based her abortion coercion claim, the first sentence of ARS 36-2153. Defendant served upon the Arizona Attorney General, the Speaker of the Arizona House of Representatives, and the President, blah, 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 blah. Okay, a motion to dismiss is not a procedure for resolving disputes about the facts or merits of a case. So there's that. And then they have all of this. A motion for judgment on the pleadings, which is brought under Rule 12 of the Arizona Rules of Civil Procedure, tests the sufficiency of the complaint and should be granted if the complaint fails to state a claim or a relief. So let's just get to the bottom. Let's see where we get the judgment. The plaintiff was not a minor when she terminated her pregnancy. The operative sentence is the first one quoted above. The sentence makes it unlawful for anyone to intimidate or coerce in any way any person to obtain an abortion. The statute does not define intimidate or coerce. The only definition pertaining to ARS 36-2153 that are present in the statutory scheme are found. Okay. The other thing is, too, is the fact that even though he wins this, he's still out for this whole thing. He's still out minimum $1,000, if not more, for just this hearing. Let me see. Let's see. So this is all of what they argued, which we just watched. And Finally, okay. It is therefore ordered granting defendant's motion to dismiss motion for judgment on the pleadings of plaintiff's abortion coercion claim, filed February 15th of 2022. All the dismissed reasons are described as above. And basically, they saw through her shit, which is great. We love it. We love to see it. You said blow. HR puff and stuff. I love it. How many of Lowe's attorneys question their choice of profession? I mean, order, stuff it, Laura. Exactly. What? That's inconceivable. This is a landmark open and shut case. Shh. Oh, we have another hearing. Yay, friends. November 15th, Laura's OOP renew request against Greg is approved, extending the OOP for 2 years. Fuck. You bring me up only to let me down. God bless it. Well, why is this like this? All right.
Shows up and he hasn't been served.
Whoop. Oh, boy.
All right, ma'am, I'm going to go ahead and call your matter now. This is FN 2022-052111, Laura Owens and Gregory Gillespie.
Laura
Ma'am, would you say your
Owens, I
full
love
name
it.
for me, please?
Yes, it's Laura Owens.
And would you please raise your right hand so that you can be sworn in by the court?
Yes,
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Maybe.
I do.
Thank you. You can put your hand down. Now, you are the plaintiff in this matter. Who is Gregory Gillespie to you?
He is an ex.
Okay.
I currently am involved
He's an ex what? He's an ex what? An ex what? I'll wait.
in litigation with him as well.
I just needed to make sure you had some sort of relationship with him. So he is an ex-boyfriend.
Please stop talking.
I did have an opportunity to review your petition, and you are alleging that he's made multiple attempts to contact you despite an active order of protection. Is that correct?
Correct.
Based on the evidence presented, then the court finds reasonable cause to believe that the defendant may commit an act of domestic violence or has committed an act of domestic violence within the last 12 months. Therefore, I'm granting the request for the order of protection and entering the following orders. I will order that Mr. Gillespie not commit.
Why?
I did have an opportunity to review your petition, and you are alleging that he's made multiple attempts to contact you.
Alleging. Oh, I guess. See, this is the problem, right? And we've talked about this. We don't want to have women like have proof because a lot of times there isn't any proof. But in this case, it's like, God.
Despite an active order of protection. Is that correct?
Correct.
Based on the evidence presented, then the court finds reasonable cause to believe that the defendant may commit an act of domestic violence or has committed an act of domestic violence within the last 12 months. Therefore, I'm granting the request for the order of protection and entering the following orders. I will order that Mr. Gillespie not commit any new crimes against you. I will order that he have no contact with you and you do not want any exceptions.
He's never committed any original crimes.
Correct?
Correct.
I will order that he not go on or near the residence listed. Does he know where you live or do I need to hide the address?
He does know where I live and I just
Okay.
am moving.
Okay. If you move and your address has changed, you need to request a modified order to reflect that new information, okay?
Okay.
You work from home, so there's no other work address to protect?
No. I have animals on the property though, and that's why I put the animals.
Okay. The defendant is ordered to stay away from animal kept or held by petitioner, defendant, or minor child who lives in either the petitioner's household or the defendant's household. I am also including your request, defendant not be permitted to contact you via text message under pseudonyms. We request the defendant not be able to watch videos on social media under his name or pseudonym to attempt to determine your whereabouts. I will include that in the order as well, okay?
Thank you so much. I
You're welcome.
really appreciate this.
Now, the order of protection does not go in effect until it is served. It will be served by a sheriff's officer as soon as possible. I don't have any control over when they serve it. I do have control over when the sheriff becomes aware of it. We usually let the sheriff know on the same day the order is issued that it needs to be served. But if you need me to, I can wait to let them know up to 72 hours. You want me to let them know today as we normally would, or do you need me to wait?
I would like for you to let them know now. Thank you.
We will notify them today. They'll serve it as soon as possible. Once it's served, it's valid for 2 years. If any of the information changes,
Mallory, it's just for punishment. It's just to punish these people. She doesn't actually want a TRO or a DVRO or whatever you call them in the state that you're in. She doesn't want it. She just wants to punish these people. She's not scared of him, because if she was scared of him, then she wouldn't try to date him. God! Oh, she makes me mad.
you must request a modified order to reflect the new information. The order of protection does not substitute for any other matters you might resolve in Superior Court. Today, you'll get copies of the order as well as the petition. Keep a copy of the order with you at all times and make extra copies. If he shows up and he hasn't been served yet, you can call the police. Let them know that you do have an order of protection that needs to be served. If they're willing, they can come, take one of your copies, use it to serve him, and then it would go into effect.
Welcome back,
He does
everyone.
have a right to request one hearing anytime while the order is in effect. So if you
Hi,
move or
Mary.
change your telephone number, be sure to notify the court.
Mhm.
That applies even if the address is protected. If you request a hearing, the court will attempt to notify you at your last known address and phone number. And if he shows up for the hearing but you do not, the order will be dismissed. Once the order is served, it's a crime to violate it. Always notify the police if you believe he's violated the order in any way.
Also, a lot of people are saying that Greg probably didn't show up so that he, just to be like, I don't care about this. Also, I think to have a DVRO against him, not only does he have to stay away from her, she has to stay away from him. So, I mean, yeah, take it.
Call the police in the city that the violation occurred in. The order of protection does not guarantee your safety, so you should take steps to keep yourself safe. That would include giving a copy of the order to the entities listed on it. You have any questions for me, ma'am?
Do I need to notify the court in the other case that the order is in effect, or is it just different?
That's up to you, ma'am. I
Superior
can't give you any legal advice. So if you have an attorney in that matter, you can talk to the attorney or you can contact the court.
Okay, I just didn't know if it was a requirement or anything. Okay.
There's
Thank
no
you so
requirement.
much. I appreciate it. Okay.
We're going to email this over to you in the next half an hour or so. Make sure you print multiple copies once you get yours, okay?
Okay, thank you so much. Have a
You're
great
welcome,
rest of your
ma'am.
day.
Thank you. You too.
Okay,
Bye-bye.
thank you. Bye.
I am late tired. Hey, you just want whatever you want? Okay, we've made it to 2023. Greg was probably working and took enough time off for this nonsense. Well, I mean, also though, I mean, I would call the cops if she tried to contact me and she had a DVRO against me. I would be like, hello? She can't contact me. If they both show up at Barry's, he has to leave. Right. This is such a waste of resources. She doesn't have to stay away. POs only work one way. If I have a PO against someone, I can call them. It's only illegal for them to answer, not me to call. I thought where I am, if you have a restraining order, you have to abide by the restraining order, or else you can also get in trouble. That's how they work where I am. So I don't know if that's different than, I don't know. But that's how, like, one of my girlfriends has one, and it's like a mutual thing. Like, you can't, if you are going to have the restraining order in place, you cannot contact them either. Huh. several filings. So February and through October of 2023, several filings are made in the abortion coercion case. I thought this was dismissed. What the hell is that? Why is that going to that? Oh, that's interesting. That just goes to here. Oh, under documents. Hold on. I thought this was dismissed though. Didn't we just see that? They will say she called me. Bacon with I'm Midwest. The general idea is that it would require her to stay away too. I can see where all the guys thought that was the case. Yeah. I had a client with an OOP. The ex-wife would have the daughter call him and say, "We have no food in the fridge." He would drop off groceries in the oh God. That's insane. Okay. So I don't know. This is taking me to another thing. So let's move on. November 9th, in the midst of her legal battle with Clayton Eckerd, Laura submits the Gillespie Connection police report, alleging Greg is violating his OOP by posting online under multiple pseudonyms. Detective Reedy of the Scottsdale Police Department finds no connection. Laura also claims Greg posted a Halloween costume picture, which she later attributed to Clayton in an OOP against him. We have time. All right. I was going to make the Gillespie Connection a separate thing, but no. We're doing it today. 33 pages. All right. We got a lot of work to do. But intentional infliction was levied by both sides. Okay. I got it. The dismissal occurred in October, so these would be the docs associated with the case. Oh, right. Okay. See? This is why I have you guys. Okay. So, I thoroughly enjoy for this. Let's see what we got. Silly. Let's go to a silly little quirky music. The way this music is going to be so perfect. And that's exactly why we are why? Yes, we've made it to the Gillespie Connection. I briefly worked with a guy who had an RO against him, and his ex kept texting him. He ignored her for a month, then responded to tell her to stop. She told the cops. That's Okay. So, let's get down to business. So she sends this counterclaim of fraud. Okay. Bye, Sarah. She sends this. These were Gillespie's counterclaim documents in the civil case I have against him. They were disproven. However, he sent these to Clayton once he discovered that I was a person accusing Clayton of being a father of unborn twins on Reddit. Okay, so he sent his stuff to show Clayton that their stuff is the same. Got it. Oh, right. So I have to say it in her voice. Got it.
So you see what happened was Greg's fiance, girlfriend, wife at the time, Instagrammed Clayton Eckerd. Then those two link up and become friends because the enemy of my enemy is my friend. So now they're like this. And Greg sends over papers to prove to Clayton that
Can you zoom out a wee bit? I got it. Disproven by who, Laura? Greg didn't send anything to Clayton. Greg's GF sent the case number to Clayton, and then Clayton went to the court to get the documents. Good point. Good point. In AZ, you have to physically go get paperwork there, not online. You're right. He did go. He told me he went to court. That's right. So we have this. I respect your opinion. I want justice for Greg. He is still dealing with her over a non-existent pregnancy. And now she is bringing his name into the Clayton case. I would love to hear what she has to say about this.
I want justice for Greg. Quote, I would love to hear what he has to say about this. Obviously, this is not a regular person online who has critical thinking skills. Obviously, this is Greg.
Oh no, the boys are talking. Possible
This is my list of possible threats.
I want the end result to be Laura M. Owens left unable to fuck over another person again. How is this a threat? Bachelor Nation, quite over. Accuser sent me phone call evidence, new Dave Neal video. If she were smart, which we know she isn't, she would slink away and hide under an Arizona boulder. She will be exposed publicly. You can run, but you can't hide. I know, I gotta get Jack. We gotta do a collab. Gossip Goose here. Back with more breadcrumbs to go along with that tea on our favorite, quote, baby mama. Word on the pond is that schemes are being spun to excuse the predicated, inconclusive paternity result. The heat of the Arizona sun, drinking too much water. What will the excuse be this time? And a gif of Dolly Parton. What the fuck?
This is the Gillespie Connection. Greg has been known to listen in on my conversations in the past because he is a master hacker. He had to be listening into my phone call with the lab, RavGen, where I asked if drinking too much water prior to taking the test could produce an inconclusive result. I had not asked anyone else except for the lab about this. Nor did I bring up this question to anyone else. It has to be him.
Put a 1 in the chat if you're actually Greg. Wile E. Coyote. Greg Master Hacker, because Greg is the FBI and can hack cell phones. Right. You leave Dolly Parton out of this. Unverified tea from a credible anonymous source. Clayton's accuser didn't take a paternity test today. We'll be taking tests tomorrow.
See above, okay? Greg had been listening into my phone call with the lab as not even Clayton knew I needed to reschedule the test for the next day. This was posted right after I hung up with the phone, probably because I was the one who wrote it. I mean, Greg. Greg was listening to my phone calls with the lab and then moved it. It's impossible that this could be me lolcowing myself on Reddit and then trying to blame it on Greg. That could never happen. Never.
Imagine submitting this to the police. This tea will leave you honking. I don't know if you guys know this, but I actually have a silly goose tits in the back. Yeah, I got my silly goose tits. Is also Greg. Everybody's Greg. And I'm in person on his behalf. 1, I'm the most Greg of all Gregs. My dog is also Greg. This tea will leave you honking. A little gosling told me an alleged baby mama requests virtual future hearings for her, quote, privacy.
Greg has a history of hacking into my email. I had requested a virtual order of protection hearing with the court via email, and this was not made public. That means he had to have been reading my sent messages. It does not mean that this was maybe me on Reddit somewhere trying to get him in trouble, trying to make him look a certain way. I could never falsify Reddit comments. Never.
Protective ring around our dolly. I identify as Greg whenever I'm watching Bacon. Greg probably is the one who hacked her $500,000 she had in the bank. Right. I'm enjoying the chats. I finally got to make a live. My poor hubby. I make him listen to all the new TA learn every day. Hey, Jules. That sentence construction is shocking. The order was real. The hearing was virtual. Yikes. My pregnancy. Fake. Another comment. How is Laura Owens allowed to keep spinning this web of lies? Clearly, her parents or family don't give a fuck, as they've been sent things on Facebook. Do her lawyers know that she's doing this? I know she doesn't have a lawyer for the Clayton case, but she's so obsessed with victim number 2 and keeps dragging his name into this, so her lawyer for that, Greg's lawyer, and the judge needs to be informed of all this shit. How is she allowed to keep accusing him of things like this while in active litigation and have no repercussions? The case docket has no update, so clearly no one is doing anything to get her to shut up. No one with any sort of power even seems to care that she is continuing to do this. Lock her up. All right, who in my chat sent this? Who's responsible for this? Which one of you motherfuckers? Oh, God. Which one? Who's taking the blame for this? I know it's one of you.
I haven't dragged victim number 2, Greg, into this at all. Greg has inserted himself at any chance he can get, including here. Also, to my knowledge, the judge has no knowledge of my pregnancy with Clayton's children because there was no pregnancy with Clayton's children. So why would she have any knowledge of them?
It was me. More comments. I think it's harder to get police/district attorneys to move on stuff like this. I don't know. Her parents have actively been deleting the comments on their Facebook. Her sister and brother-in-law made their socials private within 24 hours of her first post to Reddit. In Arizona, not having or faking a death certificate is a crime. The fact she emailed Dave Neal per today's video telling him she was going to Ravgen to take the second test tells me this shit is going to go on as long as she can drag it on. She's already dragged guy number 2 for 2.5 years.
Only Greg would know or care enough to be mentioning dragging guy number 2 for 2.5 years, which is how long our civil case has gone on. Not like anybody could have just gone and looked up papers and figured that out. It must be Greg. And only the person who has been making comments on my family's Facebook pages would be checking to see whether or not they were still up. Only Greg knew their information and would be making harassing comments.
Good Lord. Even though I'm not a subreddit. Oh, God. The fact her sister, her closest confidant, didn't share Laura's accomplishments, i.e. TEDx excerpts, doesn't share the podcast, etc., is very telling. I have not personally reached out to any of them, nor commented on socials, etc., but I have heard that people DM'd the sister, commented on several socials, etc., and they know. I don't think that they want to be involved, which might also explain the move to NYC about the time shortly after she was doing this to guy number 1.
My sister went private immediately after the story broke because she might have been horrifically embarrassed. Or maybe she's involved and didn't want people to catch her. I don't know. The only person who would know this was someone who was familiar with hers. Also, no one else involved in the situation would know when she moved to New York. Must be Greg.
I also think she should go to trial. Go to trial. How can she presume that only Greg would care about how horrible she is? There are 244 of us in here alone. Low operates as if all our victims are isolated and capable of making connections. Right. I think it was NASA. NASA actually went to space, got satellites, and did all of this. Messier and messier. Ooh, hot tea. This is Reddit. Seems Clayton's baby mama may have actually done this before. The recent news segment from Phoenix where Clayton and the news station have contacted TEDx and they don't respond. Yeah, they're probably not going to. I don't think anybody's answering those. I don't think anybody's answering those messages. I reported it to the Home Shopping Network. I tried to record it in the Department of Homeland Security, but I got confused with the initials. Yeah, it was a high school thing. I don't think anybody's answering that anymore. Because she's going to get called out on the belly video and admit her sister did crimes. Yeah, I don't know, man. So it must be true. You're all Greg. Hi, Beans. Aw, Beans. That's a cute name. So this is an order of protection.
This is an order of protection Greg apparently obtained against me. Why would he need that? The day after I filed a civil case against him. It was never served on me because I dodged the server, so it was never in effect. According to Manny Vargas, clerk at Dreamy Draw Justice Court, where this was obtained, only Greg and no one else, not even me, would have been able to get this document. Suspicious. Manny said it was obtained in person the day that it was posted, and that Greg also asked for it to be emailed to him. Hello?
An order of protection was granted against Clayton Echard's alleged baby mama in 2021, eerily similar paternity claim. And then it's got all this proof right here. 1, 2, 3, 4, 5, 6, 7, 8. How do I tag mention? So you write at, you put in the at sign, and then you put in their name. Like that. Dreamy Draw. Dreamy Draw Justice Court. Someone turned off comments on the TEDx talk, so someone has... Oh! When did they turn it off? That's interesting. Just posted on X, Mom and Pop haven't paid their bankruptcy filing fee. I thought did we not know that? Or was that for their now Chapter 11? I feel like this is Sims music. I like it. Goes along with what we're doing. Dreamy Draw was my nickname in art class.
This user is showing a chronological post of how they went to the courthouse to obtain a copy of an order of protection that Greg apparently got against me the day after I filed a civil case against him. It was never served on me, so it was never in effect. According to Manny Vargas, clerk at Dreamy Draw Justice Court, where this was obtained. Oh, I already read this, because she put it twice.
Ugh. Oh, Tiff, you're going live. All right, everybody, Tiff will be live tonight. I'll be there. I'll try to be there if my kids allow me to do anything else. We knew the comments were turned off before the news reported on it, so how many times can they use that trick? deed to the house on the hook for outstanding debt. Yeah, that's a good point. Good point. Then we have this. This is absolutely false. What does this say? My orders protection. Okay, so this is absolutely false. My other orders of protection in Maricopa County are public record. Everything filed is publicly searchable. No one saw this document because it didn't exist. Strict schedule 2441. Man, she's just sitting on Reddit. Yikes. It was definitely Greg.
Picture number 1. Background context. Laura Owens insists that Clayton is joining forces with her 2 abusive exes, X1 and Greg Gillespie, to fake evidence against her. A petition of protection document for Greg against Laura Owens was then leaked with information that jeopardizes her claims as it calls into question her previous pattern of behavior. And it's not a pattern of behavior because I clearly escalate. It gets different and worse every time. The claims that Greg makes in this leaked petition protection he filed against Laura have eerily similar details to her claims against Clayton. Oh.
I'm reading this as Laura. It's not Laura. Is it? Did I do this wrong? Oh, nope. I'm on mute? Oh, sorry. I don't know what I'm doing. Okay, wait. I was reading this as somebody else. Hold on. The claim that Greg makes is blah, blah, blah. In this image, she is claiming that the leaked document is faked because you cannot view it online in the case database for Maricopa County. Therefore, since this supposedly leaked order of protection for Greg against Laura cannot be found online in this case database, anyone who claims to have seen the real document is lying, as it's simple and it does not exist. Is all this schnitzel? Is all of it schnitzel? I wonder why I went mute or got muted. Huh. Picture 7 and 8. These documents were the order of protection attachment that the clerk emailed. You can see that the order was granted for Greg against Laura. Then we have this, picture number 2, to dispute Laura Owens' claim that the leaked petition of protection that Greg filed against her does not exist because it is not searchable in the case database online. A simple search of the Maricopa Civil Court case website states that not all documents are posted online and must be accessed in person. Jan's second bankruptcy filing. I did know. Oh my God, and now they're not paying the filing fee. They just did that to extend not having to pack up the mesita. Oh, when I switched voices. Sorry. That's all they're doing. They're just delaying the inevitable. Picture number 3. Laura then rebuttals the order of protection was never served and that it's not available in the courthouse. Therefore, since it's not available to search in the case database online, that it's not available at the courthouse, then it's fake. Laura then questions if somebody actually went to the courthouse to find the documents in person. Well, Schnitzel is Greg. Right. Forgot about that. Okay, so then here's somebody at the courthouse. Picture number 4. A Reddit user decided to look into her claim by going to the courthouse themselves to verify the document. The petition of protection that Greg filed against Laura is real. This is a picture with a timestamp where they are waiting in line to ask for the records. And that's the thing. If it's a public record, it's a public record. And anybody can go get it. Picture number 5, Reddit user received a physical copy of the leaked document, the petition of protection for Greg against Laura at the courthouse. They then took a photo with the document in front of the courthouse as proof that they did in fact go to the courthouse. With the case number, never mind. I'm not going to speculate on that. I mean, but it could be anybody who has the case number, right? Yeah, so they weren't evicted. It was postponed because they filed the bankruptcy. The foreclosure was delayed. Yep. So here's Manny Vargas. Picture number 6. The clerk also emailed the copies of the physical documents to the Reddit user. You can see the email attachment that not only was there actual documents for the petition of protection for Greg against Laura, but there was also a separate PDF document that shows the order of protection was actually granted. She went to a very prestigious high school in San Francisco. California isn't the best when it comes to education, but she got the finest. I see school was not your favorite subject in school.
Greg knew this. He knew this. Others didn't. My school wasn't even listed on my LinkedIn. But you know what was? All of the LLCs that I claimed to not be an owner of. So,
Good God. I know. She's just the trying to argue with the internet. Like, I would just turn my phone off. Back to live in real time is like trying to walk on regular ground after an hour on the treadmill. A little disorienting, but I'm here. Yep. All the filings. Let's play this crazy theory out, right? So she knows she's ovulating and gets a syringe too. Seymour. Considering there are 3 separate times she was begging for money, second loans on Facebook pages, I can't see why an agent might not submit a bid if the buyer wasn't qualified to buy the property. The agent would generate a bad professional reputation representing buyers who can't perform.
sorry. Greg had been following me and what I did online for years since we have had an active civil case for more than 2 years. The begging for money on investment real estate pages was not recent.
So you're admitting that you begged for money? I thought you were rich. I thought you were rich. Demon yawn. Filing everything at the last second, lack of discipline, lack of attention to detail, lack of doing things right, lack of being a good person, lack of accountability, lack of self-awareness. Where do we stop? Where do we stop? Ugh. How to win scariest costume contest. Anonymous woman costume includes sports bra, leggings, belly bump, unbrushed wig, quote, real Sonic motherfucker. I've never read this in full. This is so funny. Who did this? Who did this? Oh my God. If she goes to court, it will force her sister and her parents to either throw her under the bus or risk perjury themselves, lying to protect her. I hope that they find out that she did all of this to herself. Oh yeah, it should have been 1,000,000% real sonogram.
This was taken from a video on my phone that the public had access to. As mentioned before, Greg has been known to hack my devices. He's hacking all my devices.
Anonymous woman phone call confession. Shitpost on Reddit. Oh my God, she said it. He something. I haven't seen this video.
This was a splice taken out of a real phone call, taken out of context to make it appear like I had made a confession. This was posted in an effort to get people to comment on my appearance and to make them think that I had admitted to doing something that I didn't, because I'll never admit it. No one else would have the motive to try to do this.
Never mind the Dropbox. That image was in her public Dropbox. I haven't even gotten to the Dropbox part. I don't even know about all that yet. She didn't do this. Someone came forward claiming it was them that created this meme. Damn it! That would be hilarious. Right, she used that picture against him. Greg did it. There's a Reddit user who claims they made the costume. Interesting that he or she only says Greg can make this meme, but in the OOP hearing, she said it was Clayton. Right. I've never actually seen the Halloween costume. I love how she deflects the fact that supposedly these two photos were taken days between each other. Yeah. Now, I bet Clayton, Greg, and Michael can totally understand how maddening it is to see people write falsities about you. You started all this. Bye, girl. One up vote. Me.
This was before anyone had mentioned Greg's name or relation to me.
Does she not realize that, like, people are smart? What the fuck is this? What is this? After a couple weeks in, it looks like the results are in. It's a burrito ultrasound. Undefeated. I love it. Oh my God. I never get sick of this case. Shut up. You're lying.
Only Greg knew that I ate a burrito every day for lunch. I'm done with this case. I'm done.
I'm done with it. I'm fucking... What is this? Oh my God. I sent you the person that created that meme. Okay, I'll take a look at it. Oh my God. I haven't seen all of this. I've only went through part of it for my video. Oh my God. Thank you, Jen. Don't use logic. There will be no logic here. I need to make that mug. Oh my God. I can't with this anymore. I can't. Let's see. Steve didn't read off the email, but I'm guessing in person. So this is probably Steve, Reality Steve. So her proof is checks notes, a neurologist visit, a picture of her sticking her stomach out, and a very clearly faked sonogram. All very convincing stuff, and definitely normal pregnant people, and definitely stuff normal pregnant people do to tell friends they're pregnant. Jane, I'm pregnant. Look at my neurologist notes. Edit, it was a virtual visit. To this music is diabolical.
Gillespie has been known to hack into my computer and would not have known whether it was a virtual or in-person visit if he hadn't. No one knew that but me, except for the people that I told. Nobody. So.
The way I will make a burrito sonogram shirt. But wait, there's more. Wait till you hear about the fake adoption of the twins. No spoilers. No spoilers. Clayton is the third man. Can we say her name in here? Has done this to. She needs to be taken down so she cannot do this to any other men. She's dangerous. By her, do you mean Laura Michelle Owens of the Nobody Told Me Self-Help podcast? Fuck. Yeah, dog. Yeah. Lying Laura Michelle Owens of the Nobody Told Me podcast. I do mean hashtag Laura Michelle Owens of the Nobody Told Me podcast. Yeah. How are you going to spin this, Laura Michelle Owens? We all know you're reading this thread and bursting to comment, Popcorn. Does Laura Michelle Owens know that? Oh, Shells, no. Thank you guys for being here. Wait, what? Oh my God.
Nobody else had ever heard of my podcast except for Greg. Clayton is the third man. She needs to be taken down. Plus, all the harassment and calling me by name. I hate the internet.
Bachelor Nation, Clayton update. I too wonder how deep they went into the vetting process. I wonder if they know what her patterns are and what she's up to right now. She took speaking engagements away from Clayton by reaching out to those he worked with. Time for fair play. A gif, she lied. Bachelor Nation, Clayton update. You nailed it. Her bag of tricks, ongoing since her teens. The family, friends she no longer has can only do so much to act accordingly. The most frustrating thing is she's acting as an advocate on her podcast while taking validity from others with her actions. Bitch, yes. Laura Michelle Owens of the Nobody Told Me podcast is a fraud. Fraud alert. Fraud alert. Bachelor Nation, Clayton update. Gains weight by eating too many burritos, pretends she's carrying twins by pushing her stomach out with a grimace and wild horsehair. Shares videos via Dropbox, but everyone knows she's a liar. Laura Michelle Owens of the Nobody Told Me podcast. A little gif, mirror, mirror on the wall. Clayton update. That's not why he's going to the courthouse. He pulled the video down because she lied and said they weren't public record. He's going to debunk another one of her lies. She's a liar who threatens everyone with litigation to bully them into submission and silence. Expose her ass. Laura Michelle Owens of the Nobody Told Me podcast. Correction. Nobody listened to my podcast. Yeah, he's the fourth. This is much more important for the detective to look into rather than solving homicide in Scottsdale. Right. Right. All of this. Quite over. Accuser sent me phone call evidence, new Dave Neal video. Yes, the best friend of 14 years, per her Insta, has been MIA since 2018, the same time she got the RO. Makes you wonder why she lost all her friends after that. She was using a Dropbox link with email sign in from the very beginning with her first of nearly 10 posts. She then jumped to another platform that allows IP and other tracking to find the viewer. She's been in DMs trying to identify people, and it's kind of late now. It's not. What was she using? What was the other platform? It's not going away. She dragged number 1 with an extended RO until 2025. She's dragged number 2 with an ongoing case, 2+ years now. She will drag Clayton as long as she can with zero ramifications through her lies and deceit. She still needs to be exposed to protect future men. If that means talking about it, I'd rather she get the notoriety for being the abuser she is. It's not going to stop until she's outed for her lies in a public, humiliating way. Listen, spoiler alert, it doesn't even stop then. It doesn't even stop then. So there's that. Someone posted a picture of her, the same one that went on her mom's page. The comments were limited either this AM or last night. I noticed it this morning. I hope she keeps going. Oh, as Dave Neal said in his video today, everyone remembers the breaking story. She got the first punch in, but not many know or end up knowing the real or whole story. I hope she keeps going until the media picks it up and blasts all of her lies with her name attached. Not because I want to drag this out, but to protect future men. She's evil. Don't worry. She'll drag it on forever. So there's that. Jane Doe drops new evidence. Bachelor Nation. If she were smart, which we know she isn't. Oh, so then there's that. This is a text message? Where's she getting that from? Someone posted a picture of her Okay, so we saw that. Her family might pay for the upkeep, boarding, training, shows, fees, etc. for the horse, but they do not own the place, 11 Star, where the horses were boarded at with its trainers. The farm is a joke. That's an entirely different entity that does not have anything to do with her or show horse. I'm sorry. I can't see without my glasses, and I decided to wear fake lashes today. So, yeah. Thanks for rating the chat. Well, I was able to... reading the chat. Yay! Good. Clayton says there's 6. I thought there was 5. I don't know. I'm sure there's more. I'm sure. Both of her parents were in broadcasting. Her mom started the podcast, which hasn't done anything new since 2018. Her mom stopped sharing the episodes in 2022. It just recycles old content. She isn't working, never had a real job. Indeed, she's very entitled, but wanted to clear up the misconception. She definitely should be held accountable. Her job is horse. Thank you for clarifying this. Okay. So then there's Bachelor Nation. She rode 920 and 925. The pics are from the professional photographer's page, sorry. There are a ton of them with her jumping, standing, etc. Wait, hey! But I had to tell you, my 7-year-old niece and I were in the pool yesterday, and it was time to get out. I said, come on.
Crew, but had to tell you. My 7-year niece and I were in the pool yesterday, and it was time to get out. I said, come on, Toots, and she looks at me and says, boo, hiss. Tomato, tomato, tomato emoji, rolling on the floor laughing emoji, rolling on the floor laughing emoji.
Boo, his tomato, tomato. We love this. That is so cute. Thank you for that super chat, by the way. I appreciate that. Oh my God. I love that so much. I'm super... Hi, Scranton. Just hearing started, but if they actually read through the barrage of text, it's clear she was using abortion to control Greg. Right. Exactly. Then he would have included Uber, wouldn't he? Great point. Let's see. All the children yearn for the mines, so I'm out for a bit. If you're done before I return, see you all on replay. Thank you, Hound Servant. Correction, her job is horse shows against children. She doesn't even compete in the adult league. Oh my God, that's so funny. That's so much better with the accent. I know. I love it. I don't know how to change it, but I love it. Tomato. So the pics are from the photographer's page. There are a ton of them. Wait, so she's claiming to be 5 months pregnant with twins while doing horseback riding competitions. Yes. So yeah, she's been doing Blenheim all summer. That vest sure hasn't gotten any tighter despite growing for 5 months. She puts weight on, but yeah, where's the belly? LOL. Let's see. Friends, geese, and amateur investigators. It appears the anonymous woman still accusing Clayton of fathering her twins has finally made good on her promise to get off of Reddit. She has deleted her account and all post comments on the Clayton saga. Although it's been wildly entertaining, let's all cheers for a step forward in mental health today for the anonymous woman. Some people also left comments on her mother's Facebook, wonder if family intervened as well. I hope so. Not okay with people going after family normally, but I feel this is a case where they needed to be told because on the off chance she's pregnant, she is not okay. And in the more likely she's not and just made herself believe she is, she really needs help. Her mom's Facebook still allows comments. There are several posts about her recent grandkid. I'm surprised I didn't see more trolling her about the situation with her other daughter. No longer in the Kitty League. Now that she's 36, she has to compete with adults. Hell yeah. I sincerely hope Clayton sues her when the truth comes out. Nah, the Silly Goose Tits Collective is a real hero. That's what we have. We have the Silly Goose Tit. Silly Goose Tit. Just one. I like Dave Neal and his videos, but he uses our work. Just once I wanted him to say, blank, put this together. Okay. So they didn't like that they were using... that he was using Reddit posts? Oh, they want him to credit this Reddit. Okay. Anyways.
Blank is who went to the court and obtained a copy of the order of protection that was never served. This was Greg Gillespie, according to Manny Vargas of the Dreamy Draw Justice Court.
Oh man, we're really making it through. I just finished the Gillespie connection. You guys, I am on fire. I didn't realize that was so short. She's going to have to own up to either lying about all of it, or she's criminally negligent and improperly disposed of fetuses, or her doctors were incompetent. Right. Either way, we win. Either way, she goes to trial and then she goes to jail, or she admits it and she pleads guilty. And we all get to say that we were right. And we don't have to say allegedly anymore because you're guilty, right? Go to trial. Go to trial, go to trial, or take the plea deal. We don't care, cause we get to say it's true, cause you're a liar, but we'd rather see a trial. We wanna see you on that stand. Do it. We believe in you, and your lies, they're all true. Tell your story, make us believe it. We want to hear it. We believe you. Where's the moon bump? I want receipts. Old white man living in Oregon. Hi, Amy. Bacon Boots, we all know you're Greg. Greg just hacked you. What do you mean, Bacon? She's innocent. Innocent. She's innocent. All right. So then we have the police report. Is that what I just looked at? Oh, then we have the police report. So we have that. Let's see what we got here. Scottsdale Police Department. Victim rights provided. At 11:20 hours, Laura Michelle Owens called to report that Gregory S. Gillespie violated an order of protection. At approximately 14:13 hours, Blank and I were working in the city of Scottsdale. In my capacity as a Scottsdale police officer, I was wearing the standard issue Scottsdale Police blue uniform. Okay. I called Laura regarding a violation of an order of protection via online activity. She said that she learned about this approximately at 10:30. I called Laura, who informed me that she believes that her ex-significant other Gregory Gillespie had been leaking information to the press in an attempt to harass her. Laura shows with an active served order of protection between Gregory Gillespie. Oh, by the way, did this police report say that you showed to be pregnant? Because I would have loved to hear that. Had obtained a copy of the court record from a case, Unified Family Court, where allegations had been made of Laura faking a pregnancy in a past relationship. She described this document as allegations that were brought up in court, but one page of a 220-page court record. Another document is from a case between her and Gregory. She alleges that Greg has sent this private court document that he obtained through discovery to several news outlets and tabloids such as Page 6, People.com, and Daily Mail and U.S. Magazine. She said that he is leaking the above court documents out of context. Even if you put them in context, bitch, they're bad. She also alleges that Gregory has also divulged court records to a Clayton Eckerd, another person in which Laura is currently in a paternity case. But officer, they aren't talking to each other. Why are they talking to each other? They're not supposed to be friends. Laura believes that Greg is divulging these private court records in an attempt to harass and slander her image. It's not slander if it's true. These allegations have been part of stories published by the tabloids. Based on this, she believes that this constitutes harassment pursuant to her order of protection. Laura said that she received blank court documents from a Reddit user who had written about the case. Username, whatever, who sent her the documents. She said that regarding the San Francisco case, only her and Greg had been granted discovery. She recognizes the nature of the scanned documents to be unique to only her and Greg. I have no further involvement with this matter. If only we could be so lucky, sir. I received a message. This is the follow-up. I received a message from Laura Owens who informed me that she had located what she believed a falsified order of protection posted by a Reddit user. The document, which she located on the Bachelor subreddit, was uploaded to evidence.com. Using AZ Point, I located a matching unserved expired OOP between Greg Gillespie, protected person, and Laura Owens, defendant. I informed that the order was legitimate but unserved expired. Laura believes that this is a further violation of her OOP. I have no further involvement in this matter. End of report. Oh my God. Fucking hate it here. Will you be releasing? It's gonna go platinum, actually. Yeah, I should release it on vinyl. You know what? Maybe I should just record one of these sections and make it like the best section, and then I'll put it on my soundboard. Who cares what the cop was wearing? Sir, what were you wearing? Finally, a use for my favorite invented phrase, her insignificant other. Right. She's wasted so much time. Give us context. People having to wait longer for a court date because of her BS. Not usually rich, white, horsey girls that get knocked off by multiple men. Or knocked up by multiple men. Someone who gets documents, the documents are there and available to pull. Right. She doesn't, for somebody who's in a courtroom, you would think she would know how the courtroom actually works. We never miss an episode of Bachelor in Our House. Ron Owens. Right. I was working in my assigned capacity as detective with a domestic violence unit. I was conducting follow-up on the listed case. I had received this case as an aggravated harassment case. Victim Laura Owens claims the offender, Gregory Gillespie, was posting about her on social media website Reddit under pseudonyms. I contacted Laura over the phone to inquire further about her claims of being harassed. She told me that Greg is using made-up profiles and uploading them to Reddit. She also explained how a user had posted to Reddit an order of protection that Greg had against Laura that was never served. Laura told me that the only way someone could get this is if the plaintiff went to court to get the documents. Laura told me that there was a Reddit user showing that process picture by picture. Laura told me that she had called the Dreamy Draw court clerk, Manny Vargas, who confirmed Greg Gillespie had come into the Dreamy Draw court justice. Why would he be able to give away that information? Why would he be able to tell her who that was? But officer, what were you wearing? Good Lord. And he got the documents from him. Laura sent me a voice recording of her speaking to Manny, who was heard telling her only the plaintiff could have access to an unserved document. And we're sure it was Manny? Are we sure? Right, they don't tell you who pulled the documents. How many accounts in chat are actually Greg? They all are. All 241 of them. All of them. Everybody. Laura, okay, so we have that. I told Laura to send me the images of proof that she had that Greg was using multiple fake profiles to harass her. Laura sent me a PDF document containing 34 pages of images and text outlining these connections. The Greg Gillespie connection. The Gillespie connection. I contacted Manny over the phone to determine if he did know that Greg Gillespie had come into the court to get his paperwork. He advised me that he did not know who that was. Shut your mouth. I contacted Manny over the phone to determine if he did know that Greg Gillespie had come to the court to get his paperwork. He advised me that he did not know who that was. He did not know who Laura Owens was either. You know what? I'm back to loving it here. I love it here. I love it here. After I explained the situation, he advised me that he did remember an email about the situation, but other than that, nothing was out of the ordinary. He told me that it was true that an unserved order of protection would not be given out to anyone other than the plaintiff, but did not recall anyone in particular coming to the court to get this order of protection. Bro, is it her? Is that one her? Is she trying to tell people that these accounts? Is this her? I looked at the document sent to me by Laura. In the document, Laura provides screenshots and photos, then has text underneath explaining the connections to Greg. Many of the shown profiles were that of anonymous Reddit users posting negative things about Laura. I looked into several of those profiles. Reddit shows a username in the style of you/username. When you go to the profile of a Reddit user, you can see when their profile was created and what subreddits they post on. The social media site is broken down into subreddits. These are subreddits for many different topics to include Bachelor Nation, a subreddit discussing the personal lives of the TV show The Bachelor contestants. As of this writing, so she could see if they were new or not. Manny's a guy who works at the court. Oh, now that's just mean to Lo. I literally pulled the document myself. You can send it to the printer and then pay at the counter and they hand it to you. I think 99% of this shit is her trolling herself, claiming it's Greg. She knows how to... Right. I feel like that's her. Because I think she would be able to also obtain a petition or a restraining order against her, right? It's got her name on it. I would think. Insane. As of this writing, the Bachelor Nation subreddit has 56,000 members. Many of the negative comments about Laura were written on that particular subreddit. It should be noted that for an unknown amount of time, Laura herself would go to the Bachelor Nation subreddit and argue with other profiles about their thoughts on her. This could be one reason why she has so many negative comments about her. One reason? Give me one reason to stay here. Laura posted by the username of... What was her username? Right. We should buy him a fruit basket. Oh, my God. Laura goes on to claim that many of these profiles were Greg posting about her with knowledge only he could know. However, many of the... Hello? Laura goes on to claim that many of these profiles were Greg posting about her with knowledge only he could know. However, many of the profiles she claims are Greg were created many years ago. Laura has listed several profiles as being Greg. I just got here, seeing we're having fun as usual. She would probably have more positive comments about her on social media if she just posted cookie recipes. Maybe. Maybe. Not berries, and now I have to personally go train people. Train them on, may everyone have a very uncoerced day. And nobody told me I wasn't pregnant. Oh my God. Due to the wide range of accounts that were created from 2016 to 2023, it is unlikely that they are all Greg Gillespie. Well, little did you know that he's a master hacker and time traveler. So, One particular claim that is that blank posted pictures of an anonymous Redditor posting pictures showing they were at Dreamy Draw Justice. God bless it. Say that 10 times fast. Dreamy Draw Justice Court to get the order of protection that Gregory had against Laura. Laura told me this was proof. Proof the Greg was blank. However, when I went to the profile page of blank, there were no pictures posted from their account. Blank reposted the picture and cited an anonymous Redditor. On pages 8 through 13 on the PDF Laura sent me, it appears to show that it is from the user blank. Laura then made me aware there was a subreddit dedicated to her specifically called Laura Owens. Laura claimed that this was more cyberbullying by either Greg or a man named Clayton Eckerd. When I looked up the subreddit, I could see there were 451 people subscribed to that page and numerous posts each day about her from various Reddit users. I could not see a clear connection to Greg Gillespie in any of these posts made on Reddit. Dude, that Reddit must have pissed her off. Narrator, Laura is Greg. I'm Greg. I just ripped my face off. Maybe Bacon hates cookies. Bacon can't bake. Bacon can only cook. Greg exists on all timelines. Oh my God. Maybe restaurant reviews. Right. Right. I have brownies in my teeth. Sorry. I spoke with Greg on the phone today and asked him, oh shit. I spoke with Greg on the phone today and asked him about the situation. Greg denied having any Reddit accounts and told me I have never had a Reddit account. He also told me that he did, in fact, go to the Dreamy Draw Justice Clerk to have the previous order of protection against Laura for a civil trial he is currently dealing with. So I have to tell you, I don't know how to change my Reddit name. The only reason I got a Reddit was because people were talking about me when I was talking about this case. So I got a Reddit and it's like zealous comedian or something like that. I don't even know what that is. And I'm like, how do I change this? How do I change it? I am old. I don't know what to do. He told me he took photographs of the document to prove that he had this against Laura, but denied ever posting those photographs to Reddit. Greg denied having any contact with her and told me the last time he ever had contact with Laura was sometime around August of 2021. Greg advised me that he had nothing to hide and would be fine answering any further questions I had. So, who did he send them to? Yeah, bacon can't bake. I can't. Even when and maybe it's my oven, even when I directly do things from the box. No, it's not my oven because my sister has baked and it's been wonderful. So it's just me. You can only start over? No, but it picked it for me. I wasn't able to pick it. It just picked one for me. Oh. But her taste in men seems excellent. Greg went on to tell me that Laura currently has filed a civil lawsuit against him and Clayton Eckerd. Greg told me that, and somebody else, which I'm assuming Michael Maricini. Greg told me that he believes Laura is doing these things to get at them during their ongoing civil lawsuit. This concludes my involvement in this situation. He's like, and I will be signing up for therapy. Thank you. Oy. You guys, we are flying today. Flying. I got about 20 minutes before I got to go. Bake off. Bake off. Bake off. All right, where are we at? All right, this is an hour and 42 minutes, so we're not going to watch this. This is also with Clayton. We'll get there because we're going to go through all of that too. So here's a minute entry. Finding neither Laura nor Greg presented sufficient evidence to prove their respective claims. All right. We did watch this, but we'll watch it again just so it could be in order. So as of right now, we are going to cut this stream. Not the stream, but just my talking about this. And then I'll just hang out with the chat. So we'll do that. And you guys can just hang out with me. You guys, we got through a lot today. So we are going to watch, next time is going to be, do you guys want to watch that hearing again just so it could be in order? Does it matter? Do you care? We'll put it's November 9th hearing. I know you've all seen it a million times. I know some of you have seen it in passing here. November 9th hearing. Greg Gillespie. If you care, we'll do it. If you don't, we'll do it. Whatever you guys want. Seems like I lost all my points or whatever. It really doesn't matter too much. No one knows who I am in there. You get points for being on Reddit? Really? I didn't know that. Baking, just religiously following directions to a T. I'm so bad at it. I hate Reddit. It blocked my stir crazy name and wouldn't tell me why. Oh, interesting. That's weird that it wouldn't tell you why. Baking is my middle name. Can't do it. Can't do it. Thank you all. The love I have gotten about my hair today has been so nice. You guys are so nice. Lo does this because she doesn't want anybody to be happy without her, which is funny because people can't be happy with her. Once people find something better, she becomes forgettable, so she imposes herself to remain permanent. It's sad. Whatever helps your channel and anyone new. What do you mean? Let's see. Have you watched the Judge Judy hearing with Clayton? No. We're gonna get there. We're gonna go through all of Clayton's. We'll go through all of Mike's. We're here for the foreseeable future. I'm writing, although I am writing my Mackenzie Sharilla script right now, so that'll be a long form video. And because I'm doing lives every day, I can make my long form videos much longer. So hope you guys enjoy that. So what's 1,000,001? Okay, so then we'll just do that on Friday. So this week I have Monday, Wednesday, Friday. Starting next week, I'll have Monday, Wednesday, Friday at 11, and then I'll have Tuesday and Thursday at about 8 o'clock because that's when my son will get on the bus and my daughter will be in camp. So then I'll be able to stream 4 days a week, 5 days a week. It's going to be great. We're going to be great. Mine is just straight. It won't do anything without major effort. So I have a waver. I have a big like crimper, and that's what I did my hair with today. Sorry, I'm talking and I have food in my mouth. I just gotta eat. And then when my kids go back to school, it'll be every day again for the foreseeable future. Mr. Pike! I missed you. Where are you? I love you. What am I doing here? How are you, Mr. Pike? It does go by feeling. But, yeah, you know what? I gotta tell you guys, like, I never intended on being a live stream channel. I always thought that I was just gonna do long form and that I would just do, like, live streaming when I could. But I've told my husband, I was like, you know what? With the live streaming, it's just so spontaneous and fun, and it's just so different, and there's no script, and there's no, I mean, there's a plan, there's a general plan, but there's no like sit down, read a script in a teleprompter, and then that's it. And like we just get to be here together and we get to experience it together, and it's so fun every single day. And I never thought that I would be a live streamer. I just thought that I would do YouTube videos and that I would plan them and do them, and that is what it would be. And I mean, I've live streamed before. I loved it, but I just thought that people wanted long form content. So when you guys really started gravitating towards the live streams, it's just been so great. It's been so wonderful. Jealous of your hair. Mine is straight and wavy in the wrong places. Mine is very straight. Very straight. So much baking, going to be terrible for our cholesterol, but great for our entertainment. Also watch Killer Cases. Oh, so my sister was telling me this, that a lot of these other ones are way better than the Netflix one. And I have read some of the like police reports, which I think we should do in the text messages on live one day. But I'm going to add like what they left out Because I don't understand, like, Netflix, you have the evidence. Why are you leaving shit out? I've been here all stream. Oh, you have? Have I missed you this whole Mr. Pike, I am so sorry. I am so sorry. Or my hair turns yellow. Maybe I should get a perm. Is your hair blonde and it's turning yellow? Because that would tell me that the heat is too high if it's turning yellow. Yeah, I gotta get him back. He's busy. I love the dog ears. Yeah, I cut mine all off because it was crunchy. It was like down to here. I wanted to grow back though because I felt so girly. My hair used to be short. When I met my husband, I had like a mohawk. All hail King Julian! Live streaming is so fun. Yeah, I like this sense of community, but also like, yeah, I just like sitting down and talking with people. Like, there's no part of me that ever wants to be in an echo chamber. I learned so much from you guys. And also just different perspectives. Like, I'll have an opinion and somebody will have a differing opinion. And I'm like, you know what? That's a good point. Ooh, growing plants indoors. I like that. Bacon Bears for boosting the volume on this. I never listened to these lawsuits with Greg very well because I can't hear it. Oh, always, no, please tell me if you guys can't hear it and you need something. And everyone in your chat, everyone in here is so wonderful. My mom got a perm in the late 70s. My brother and I died laughing. She looked like Gene Simmons. She never did it again. I've only gotten one perm in my life, and it only took on one side. So when I asked her if I could have like a refund, and she was like, no. And I'm like, this part of my hair is straight. I'm like, what? I was also like 18. It's a way to connect and interact with your audience. And live, you get to meet all the Gregs. That's right, because we're the best. I'll admit it. We like your personality. You guys are so sweet. Omar really hates the Netflix ones for their lack of accuracy. Yeah, it's so bizarre. It's like 90s hair. Dude, my daughter, I bought her a choker yesterday and she's been wearing it and it's one of those like squiggly plastic ones. It's adorable. It's adorable, girl. Adorable. Did you see Steve Chirilla's interview on TMZ? Oh my God, that guy sucks. Sucks. If you ever do the Ed Gein case, Netflix fucked it up. Ed Gein's a wild one, man. Purple shampoo? Yes, it does. Oh, yeah. Okay. That makes more sense. That was such a good time. I want to throw a panel for my birthday. That's what I want to do. You know what? I should just open it up and like if people want to come in for my birthday, we can. Do I have any interviews coming up? No, I've actually slowed down. I had to take a little bit of a break from collabing with people and interviewing because it was like everything was going so fast. I felt myself burning out a little bit. So I have to get back on it. I have my hit list right here. I still got to go with Echoes. You guys got Tug. I reached out to Runkle. I've never heard back. Nick Starro. Nick Starro is so funny. MG Law, Robin Psychic. I asked her. Dave Neal, I asked him. We was just like scheduling stuff. All of these people. Ducky's down here. So, when is my birthday? It's the 11th, June 11th. Birthday streams are the best. I still have my squiggly plastic ones from the 90s and I have a matching bracelet. It's so cute. I asked my hairstylist when it was going to grow out and she said, those are your curls now. I suddenly had natural curl. After it? Huh. Mackenzie's dad permanently lost his job. I thought he was just on leave, teaching leave. It feels close. So, it's a real bummer. My birthday is on the 11th, and so they had reached out to me, and they're like, do you want to do the fundraiser? We have the 13th or the 27th, and I was free on the 27th because my sister's graduation party, we're throwing her graduation party. That's on June 13th at my house, so I won't be available that day. I feel really bad because they came and they did ours, and I won't be able to do theirs, but I can't. I gotta be there for Little Ham. So we're throwing the graduation party, and we start when we throw parties over here. We got to go early in the morning, girl, because we get everything set up and then we party until late at night. We are a party house. It's so funny because little Ham was like, your house comes alive in the summer. And I'm like, yeah, it's just people walking in, walking out. It's great. But yeah, I won't be present for theirs, which I feel really bad. But my family stuff always comes first. So I got to do it. You and Dave will be fire together. I got to reach out to him again. I can pull your tarot cards. Yes! Yes! I want this. I would have gotten natural puberty. Oh. And her future breakup. Oh, is your sister back from her trip? No. Mm-mm. She won't be back until Saturday. But let me tell you, she's having a good time. Oh! The aunt messaged her, by the way, and was like, why would you tell people that I kicked you out of your house? Hello? Like, is that not what happened? What? Okay. And her dad are awful too. Those alone should make sure he's never... I have not seen this. I have not seen the text messages. But anyways, all right. I must go relieve our babysitter, which is... Were they watching? Excuse me? No, they weren't watching. And even if they were, let them. But no, I guess it got back to her that somebody was like, they kicked her out, whatever. So, okay. So also my sister, her two best friends, okay, sorry, hold on. Both of my sisters and two of her best friends all work at the same place, which is where her ex-fiance used to work. And there's a lot of people who work there who were friends with her ex-fiance's family. So my sister and one of her friends was going back and they were telling the story of what happened, which got back to the family. She sends an 8-page dissertation to my sister of how could you do this to me? So anyways. I heard a quote last night that said, when people can't control you, they try to control how people see you. And that's exactly what's happening right now. They all know that they did her wrong. They're all trying to backpedal. Sucks to suck. Don't be a shitty person, and then people won't be able to tell shitty stories. So there's that. Anyways, if you guys aren't subscribed already, please consider doing so. If you aren't, if you haven't liked or hyped or smashed your face against the keyboard, that would also be great. It helps out the channel. Thank you for all the super chats today. Thank you for being here. Thank you for subscribing. Thank you for being members. You guys are the best. I won't be on tomorrow. I will be on Friday. And then next week, we'll start 5 days a week. You guys are the best. Okay? Bye-bye.